the second to the last day of the 2021 interim revenue committee meetings. I know I'm happy about that, at least that being that part. So Josh, would you care to call the roll, please? Or who's going to call? Emily, thank you.
Good morning, Mr. Chairman. Senator Baldwin.
Here.
Senator James.
Here.
Senator Pappas.
Excused. Hopefully he'll be here tomorrow morning.
Senator Schuler. Here. Representative Baker. Representative Gray.
Excused.
Representative Hallinan.
Excused.
Representative Henderson.
Excused.
Representative Jennings. Representative Roscoe. Representative Sweeney. Representative Yen.
Excused.
Co-Chairman Harshman.
Here.
Chairman Case.
Present. All right. Would you guys mind introducing staff going around for everybody? Josh, let's start with you.
Sure, Mr. Chairman. Josh Anderson, LSO attorney.
I don't think that mic was on, but
Oh, should be on. Good morning, Anna Johnson, LSO staff attorney.
hello.
Dean Temte, budget fiscal section.
Welcome, Dean.
Emily Wongan, legislative editor.
Thank you. Welcome, everybody. There's been some changes and I was just grateful that you would introduce yourselves and thank you so much. I find it kind of ironic, Mr. Co-Chairman, that we are deep down in the basement of the Capitol looking desperately for money to fund this state. And at this very moment, the Appropriations Committee is in the party room at the top of the Capitol, smoking cigars, I'm sure, and spending, they have more money than they can possibly deal with all this ARPA funding. So here we are doing the good work that the people deserve while they're up there spending it like crazy. So just keep that in mind. With that, the first, if there are no other opening remarks, we'll go ahead and get started with eligibility of sales tax exemptions, 22 LSO 217. Mr. Anderson, welcome.
Thank you, Mr. Chairman. Josh Anderson, LSO. So this bill 22 LSO 217 working draft 0.4, this came out of the September meeting towards the end of September there with the discussions on the workforce protection. And this idea came up to have some sort of a checklist or similar to qualify for exemptions. So that was the genesis of this bill. Just quickly into the bill, Mr. Chairman, on to page 2. It says that to qualify for any exemption under this paragraph, the vendor or taxpayer claiming the exemption shall file a certification of eligibility with the department as provided in subsection C. I would note there that that paragraph are the tax exemptions for economic incentives. That said, it's possible that could be too broad. If you look through that list of exemptions, there might be some that you wouldn't necessarily want to have someone to qualify for. Sales of school annuals, newspapers, and there are others, Mr. Chairman. So I didn't want to make that policy call, but certainly something the committee might want to look into on which exemptions you would specifically want or not want this to apply to. But then, Mr. Chairman, on subsection C there, says before receiving any exemption under that paragraph, the vendor or taxpayer claiming the exemption shall file a certification of eligibility with the department. The vendor or taxpayer shall certify under penalty of perjury that the vendor or taxpayer has employed Wyoming resident workers to the extent practicable, and that the vendor or taxpayer has informed the non-resident workers who are working in Wyoming of the need to comply with the vehicle registration which is currently in our statute, and that was one that was specifically mentioned at that last meeting.
Mhm.
Continues on, Mr. Chairman, each certification shall be on a form prescribed by the department, and then includes a definition of resident as a current definition. And then the rest of the bill, again, the next one there in 3916, that applies to the use tax, but otherwise the same set of exemptions for the most part. It does clarify that it would apply to exemptions on and after January 1 of 2023. And that's the bill, Mr. Chairman. I take any questions.
I'm sorry, Mr. Coach. Oh, two on. Oh, we don't note. We've got Representative Yen and Representative Hallinan have joined us. So we note that with our welcome to both of you. Okay, questions for Mr. Anderson? Mr. Jennings, Representative Jennings.
Thank you, Mr. Chairman. Josh, could you go back over, I mean, I remember this being discussion about people from out of state being in parking lots. Could you go back over and touch on what is currently in statute, what is required of these people now, what's currently in law?
Mr. Anderson, if you can.
Mr. Chairman, I don't have that statute. It's the one referenced in there. It's 31-201A4. I think it's a certain amount of time. If you're out of state resident working in this state, you're required to register your vehicle in this state. I have to look at the specifics.
Seems to me that it was 30 or 45 days, but we ought to be able to look that up pretty easily.
Yeah.
Go ahead and back to you, Representative Jennings.
Thank you, Mr. Chairman. So in looking this stuff up, was there any information on how much of that was being enforced currently?
Mr. Anderson, if you can.
Mr. Chairman, no, I'm not aware of how that's being enforced. You know, I did look into it, you know, the question arose, you know, if you're in Colorado and you work in Wyoming, but you live in Colorado, you would still be required to have a registration in Colorado, but then Wyoming would also require you to register your vehicle in Wyoming. So I'm not sure on the interplay of how that works or how it could be enforced. That was one question that came up when we were looking into this, but no, Mr. Chairman, I'm not aware of the amount this is enforced currently.
Anything else? Representative Roscoe?
No, thank you, Mr. Chairman. Josh, do you know how many states we have reciprocal agreements with so that, you know, so we allow interstate workers for like people in Wyoming to work in Colorado and they can work here in.
Mr. Anderson?
Mr. Chairman, Representative Roscoe, no, I'm not aware of that. Like I said, this statute 31-201 that requires vehicle registration, it didn't seem to have any exemptions for any other states or anything. So it would generally apply to any out-of-state person working in Wyoming, and for that certain amount of time, which I'm not sure how long it is, if it's 30 or 45 days. I can get that answer for you here in a minute, Mr. Chairman.
Okay. Anybody else? Any questions for Mr. Anderson? Thank you, Mr. Anderson. Stay close. Who else would like to testify on this bill? Anybody else like to testify on this bill? Anybody else? I'm not seeing any testimony either here, nothing online, correct? No hands up in the waiting room or anything like that?
Mr. Chairman, nobody has their hand raised right now.
Okay, thank you. So committee, we don't have any further testimony. You've heard the discussion. Is there a motion on the bill? Or do you want to discuss it first? Oh, I'm sorry. I didn't realize that. Go ahead, Representative Jennings. We have another question. You can take it from over there, Mr. Anderson.
Yeah, thank you, Mr. Chairman. So under the current, if there's non-compliance by the company, what is the current penalty? Thank you, Mr. Chairman.
Mr. Anderson?
Mr. Chairman, I don't believe there's any requirement on the company currently. It's a personal requirement of the owner of the vehicle. So it would be on the worker rather than on the employer. And I'm trying to look at that statute real quick, Mr. Chairman, if you give me 1 second.
So there must be some kind of penalty to have a vehicle in Wyoming and not have it be legally registered in Wyoming, but that's on the employee, the owner of the vehicles. So, I do recall from some of the earlier discussion and in discussion in past about this issue is once in a while, county officials will look at the go through the parking lot of construction site and, let people know. I've heard of that happening anecdotally and I would think very rarely, but it certainly has happened. I bet you Ms. Henson remembers stories about that, but it would not be the function of the county assessor necessarily, although the county assessor, we get tax revenue from registration of vehicles. That's why we want them to be registered, but it would be kind of the clerk and the treasurer's office that would be involved in that. I don't know if that's helpful or not. Anything further?
Just curious about the penalty of
Yeah,
what is currently available. Thank you, Mr.
still
Chairman.
we'll keep working on that. If Mr. Anderson finds it, he can interrupt us. Any other discussion? Well, it seems to me that if there's no more discussion, I know we're waiting on one piece, but we either have to have a motion on the bill to move forward or not. Representative Yan. Is
Mr.
that a
Chairman,
motion?
I'll move the bill. Yeah, I'll move the bill.
Thank you, Representative Yan. Motion by Yan. Is there a second? A second by Hallinan. So discussion. Go ahead, Representative Jennings. I think this is probably one of your favorite bills of the day so far.
It's a good start. so far.
Go ahead.
I'm a little trepidatious with this because I don't know what the penalty is. We're going to shift this from the individual to the company. And the individual, we don't know what is going on out there, except we think that basically nothing. And so I think a lot of times we have the reaction to find somebody new to shift the burden to. And I certainly, without knowing what the penalty is and what can be done currently, I'm certainly a no and would urge a no on this. Thank you, Mr. Chairman.
So Representative Jennings, here's how I read the bill. This is a bill that is a certification requirement for an employer to qualify for a tax exemption. And in the certification, they say that they're trying their best to employ Wyoming workers. That's one check mark. And secondly, that they have informed their non-resident workers that they need to register their vehicles in Wyoming. That's the second checkbox. If they can't certify that they have done those two things, then they don't qualify for the exemption. But I wouldn't think that there's any other penalty. They want to qualify for the exemption. And so it seems a pretty simple thing for an employer to say with a sign on the gate, don't forget to get your vehicle registered if you've been in Wyoming for 30 days or 45 days or whatever. I'm not sure that I see your point about it being onerous. The downside is that you don't get the exemption. Anybody else? Representative Sweeney.
Thank you, Mr. Chairman. So my recollection on the testimony that we heard last time was specifically about an operation here during a turnaround, and which also occurs outside of Rollins every couple of years in Natrona County, a major turn, which can last 6 weeks, 8 weeks. And all of that technical ability, a lot of it comes from Texas. A lot of those companies are down there to do this specialized type of work on refineries in particular. So I think what we were trying to get after was a way to level the playing field a little bit on those workers. But filing for this exemption, if I'm reading this right and understanding that, I think it should be the responsibility of those different companies. There's a lot of different individual, whether it's specialized welding and X-raying and all sorts of different companies come to town for those things. So I think this is hopefully solving some of those issues and clarifying. So I think I'm fine with, voting in favor.
Okay. Further discussion? Is that you, Dr. Hallinan?
No, thank you, Mr.
I confess that I have, here's
Just
what,
scratching my face.
okay. I stepped on my other pair of glasses. And so I have an old pair of glasses and they're not bifocals. So when I have my glasses on, I can see everything perfectly, like past my arms. With them on, I can't see a thing like within 2 feet. So holler at me if I look like I'm not seeing you. Who were you pointing at? Representative Schuler,
I'll start doing that.
Senator Schuler.
Thank you, Mr. Co-Chairman. The only thing I have a question about, I guess, is whether or not the Revenue Department will be able to follow up. And maybe, I hope it's not an undue pressure on them to try and figure out whether or not the vendor or the taxpayer has done their due diligence. So I like the idea of putting it back on the taxpayer and the vendor, making them, if they want the exemption, to do the work and fill out the certification. But I just wondered about the Revenue Department, if that would be an issue for them. Thank you.
Would the Revenue Department like to address this? Ms. Lucero, welcome.
Good morning, Mr. Chairman, members of the committee. I think the one thing I would like to say about this bill is the discussion in the past about the company and all the out-of-state workers that came in a turnaround.
Mhm.
The contractors typically aren't the ones that are gaining the exemption here. Okay, so these exemptions are like the data center exemption, the manufacturing exemption, some of the smaller ones that Mr. Anderson mentioned as well.
You might pull that mic just a little bit closer.
So the contractors that are coming into the state with the out-of-state vehicles, they aren't the ones that claim the exemption. It would be the company.
Mhm.
So I'm not sure how much luck we would have knowing that the company hired contractors to come work in their specialized turnaround field or whatever. How much luck that we would know how to say, to the extent practical, that they hired Wyoming people, because a lot of those things are very specialized. And then the company would not be allowed to get the manufacturing machinery exemption, for instance,
Mhm.
for the machinery that they're using based on contractors coming into the state that they may not be able to hire Wyoming contractors for. But I'm not sure it's certifying to us that, to the extent possible, I think we'd need a little clearer direction on what that means.
I thought you'd just solve it in rules, actually. So you guys would figure it out. Questions for Ms. Lucero? Representative Jennings?
Mr. Chairman, you beat me. I wasn't sure I was going to ask it, but since you
I can
called
tell
on
when you're
me,
getting-
I'll go ahead.
You're heading for.
So from the department's perspective, it seems to me, I mean, that Mr. Anderson's looking for, but it seems to me like this is already against the law. When they come, they should register. So it seems like that if we put things like practicable, that seems very arbitrary. That for one company, it might be, they thought that they had done that. And so it seems to me like that we're shifting this really so that the company can't get an exemption. but it seems like it's arbitrary enough that it would create a problem when there's already law in place that the individual is supposed to be taking care of this now. Is that kind of what you're saying there, is that there's a problem of the arbitrariness of certifying how they've done Wyoming workers?
Ms. Lucero, if you can.
Mr. Chairman, Representative Jennings, yes. I don't know how I would know if there's Wyoming workers available to do the work that's necessary to be done. And so do I just send them a form saying, can you certify to me that you attempted to hire Wyoming people and you've told them that they're supposed to register their vehicle? If that's all that's expected of the department, I mean, we can do that. But I don't know that we would be able to say, no, you haven't, or yes, you have. I mean, how would we deny that exemption? On what premise?
Well, I think, Ms. Lucero, that you're correct. It just says that before they receive the exemption, and in line 15, they shall file a certification of eligibility with the department. And that it seems to have two things. And so I guess they put in for the exemption, you go and look to see if they filed their certificate of eligibility. And we'd have to have rules to decide if that's a one-time thing, or I would assume it's an annual certification, for example. What's involved in that? What does the form look like? Is there a penalty for a false filing? That might be, that's a little different than not complying with the law. There might be a penalty for false filing. And that would be somewhere in the law. That's a good question. But do you have enforcement? What would the enforcement look like? All up in the air and all up to the department's rules. Any other questions for Ms. Lucero? I'm sure they're really delighted about this bill over there at the Department of Revenue.
Mr. Chairman, the other
Ms.
thing
Lucero.
that I would mention is that, you know, the manufacturing machinery exemption or the data center or any of these exemptions in the economic incentive area of the statute does allow them currently to just take it. So we don't even know when they take it.
Mhm.
And we do survey some of the like manufacturers, for instance, to gain some information on how often it's used in the dollar amount that we're missing collecting sales tax on. So I don't know if this would be for every purchase, every year. I mean, because these are ongoing purchases. And for the data center exemption, for example, already has qualifications that they have to spend so much money every year and make a capital investment, you know, before they even qualify for those. So it kind of is an interplay that's interesting, at least, that might make it a little difficult to verify some of this stuff.
Yeah. Let's go back to the bill, Ms. Lucero. So I think this is an additional qualification to receive those exemptions. And it just, so before they get that exemption by that criteria, they'd have to certify that these two things. They tried their best to employ Wyoming workers, and that they told the workers they need to register their vehicle if they're in the state long enough. So it is another step, I think. Any further questions for Ms. Lucero? Josh, do you have any revelations?
Mr. Chairman, so first, I think I couldn't find a specific penalty for failure to register for non-residents. So I believe the penalty then is the general penalty, which is $750 fine. And again, this would apply to the person owning the car or needing to register the car. So it wouldn't apply to the business claiming the exemption necessarily. And then, as you noted, there is on page on page 2. Let me find it real quick. page 2, line 17, that the
Right.
certification is made under penalty of perjury. So there would be a potential penalty if the person makes a false certification. Again, it would be, as Ms. Lucero noted, it'd be, somewhat difficult to prove, what to the extent practicable means. From my understanding, Mr. Chairman, this was more of a bill to, kind of signal that the state was interested in these issues. But there's, as Ms. Lucero noted, it would be somewhat difficult to enforce if it was asking the department to make those determinations. I don't believe the bill necessarily does that, just requires the person or claiming the exemption to file that they believe they're complying with these requirements, Mr. Chairman.
Thank you very much, Mr. Anderson. Does that clear things up for some folks? I think if you recall the history of this, it was proposed that there originally, I believe it was Ms. Johnson, who represents, I'm not sure, I can't remember which union, but represents Wyoming Labor, suggested that we need to be stronger about our policies to employ Wyoming residents rather than out-of-state folks. And so, but there were a lot of problems with that. We talked in terms of there possibly being interstate commerce issues about in-state versus out-of-state, for example, and on and on. So it came down to really more of a statement bill, which is that they have to just certify that they're hiring residents and that the hiring residents to the extent they can. And secondly, that they're telling the out-of-state folks to register their vehicles in Wyoming. That's it. And it's just perhaps a statement bill that's a reminder that it's important to hire in-state folks when we can. And it's hard to disagree with that. But I suspect in terms of being problematic, I'm sure the department doesn't like having to come up with a form. I'm sure employers don't like to check this off, but does it achieve its purpose of encouraging more Wyoming residents? I can't tell you. But I think that's the way the bill is now. So is there any further discussion on the bill? Anybody in the audience here? Anybody online? Representative Yin.
Mr. Chairman, thanks. Yeah, I just wanted to say that, sales tax exemptions are something that the state gives as essentially a benefit to a taxpayer for some sort of economic benefit or social benefit to the entire state or constituents or residents. And having some sort of accountability on how that exemption is placed, I think self-certifying is the bare minimum. And at the very least, it does put a reminder in front of every taxpayer that, you get the sales tax exemption, but it should provide the benefit that we're asking, which is, promoting Wyoming workers and hiring people who live and work in Wyoming. So I urge you to vote yes. Thank you, Mr. Chairman.
Thank you, Representative Yen. Representative Jennings.
Thank you, Mr. Chairman. So Representative Yen brings up a kind of a new question for me. So is there not currently in the exemption part of that if the company, let's say the company comes and they do not register their cars, and we've heard that the penalty is $750, is not the exemption already on the line for them not doing that?
Josh, can you help with that? My thinking would be no, but
Yeah, so Mr. Chairman, again, I think, the penalty would be on the employee, not registering their car. It wouldn't have any real impact, to my understanding, on the employer who is claiming the exemption.
anybody else? Anybody else? You ready for the question?
Question.
Let's have a roll call. The roll call will be on 22 LSO 217, sales tax exemptions certify eligibility.
Senator Baldwin,
Aye.
Senator James, Senator Pappas,
Excused.
Senator Schuler. Representative Baker. Representative Gray.
Excused. Let's finish the vote and we'll discuss proxies if that's all right.
Representative Hallinan.
Aye.
Representative Henderson.
Excused.
Representative Jennings. Representative Roscoe. Representative Sweeney. Representative Ian.
Aye.
Co-Chairman Harshman. Chairman Case.
Aye. The whole world awaits.
Mr. Chairman, I have 1, 2, 3, 4, 5, 6 ayes, 2, 3, 4, 5 noes, and 3 excused.
Thank you. So the bill has failed. It didn't receive a majority of the committee. With respect to proxies, the chairman and I have discussed proxies. We'll allow proxies if you've heard the testimony. We're not going to allow proxies if you're not present, at least hear part of the testimony. So if you made most of the meeting and but you had to dash out, you can leave a proxy. But if you haven't heard the basis of the testimony, we're not allowing proxies. All right, what's the next bill? And Josh, just to be really careful, did I call that vote right? Or is it for committee rules? Is it a majority present or majority of the committee? So stand by that last call on the vote till we research that, okay? So let's just leave it open, no problem. And we'll see what that says. Okay, so we'll stand by. The next bill is business franchise tax and reporting. We've got LSO 218 and LSO 219. Josh, we'll come back to the issue of the quorum and things like that. So don't feel pressured by that.
Mr. Chairman, as you noted, yeah, we have 2 bills here related to a business franchise tax that was discussed at the September meeting based upon some of the previous work of this committee looking into gross receipts tax. So the first bill, Mr. Chairman, reporting on a business franchise tax was 22 LSO 218 draft 0.3. This was based on a previous bill sponsored by this committee. It was 2018 House Bill 51. Just quickly getting into the bill, Mr. Chairman. This would require every entity that's required to file an annual report and pay a fee to the Secretary of State to report additional information that would help in kind of estimating what a business franchise tax might generate. So if you'll see on page 2, it would require reporting of total gross receipts for federal tax purposes, the portion of gross receipts earned in Wyoming, the home state of the entity for federal income tax allocation, and the total payroll of the entity in the state of Wyoming. The previous version of this bill required them to also report NAICS codes instead of the payroll. Currently, the idea of the business franchise tax doesn't look into what NAICS code the entity uses, so sub that piece of information out for payroll. Mr. Chairman, then bottom of page 2, it requires the information to be kept confidential, provided that the Secretary of State can submit aggregated information without individual identifying information to the Department of Revenue and to this committee for the purpose of developing and considering legislation. It requires the Secretary of State to adopt rules and to make changes to their electronic filing system. And here, Mr. Chairman, I had some discussions with the Secretary of State's office, and due to some miscommunication there. So I believe the first one, it said the rules shall authorize nonprofit corporations, low profit limited liability companies, and decentralized autonomous organizations and other similar classes of entities to answer not applicable on the information required under this section. I believe that likely want to remove, and the Secretary of State's office can speak to this as well, but I believe we'll want to remove low profit limited liability companies and decentralized autonomous organizations. That was a misunderstanding that I had from my discussion with them. Mr. Chairman, the bill requires the rules to be implemented not later than June 30 of 2023, and would require the reporting on and after that date.
Should we ask questions on, instead of piling on, if there are any questions for Mr. Anderson on this bill, go ahead. Senator Schuler.
Thank you, Mr. Chairman. And again, I may not have heard what you said about nonprofits. Could you just clarify that again? What?
Mr. Anderson.
Sure, Mr. Chairman, Senator Schuler. Yeah, it would just allow the Secretary of State to make sure that no nonprofit corporations can answer not applicable, as they would not likely be subject to the tax. So they would not have to report this information. And it would give the Secretary of State the ability to allow that for other types of entities likely not subject to the tax. Try to make clear that they don't have to collect this information from all kinds of entities that wouldn't necessarily be subject to the tax.
Anybody else? Representative Sweeney.
Thank you, Mr. Chairman. So Josh, just for clarity, so page 3, line 12, starting on line 12, is that where you're saying should be removed?
Correct, Mr. Chairman, Representative Sweeney. So could remove, again, the Secretary of State can likely respond to this, but I believe remove the reference to low profit limited liability companies and decentralized autonomous organizations, going down to 14.
I'm certainly a low profit organization, let me tell you. Anyway, any other questions for Mr. Anderson? Anybody else? Okay, anybody online? Not seeing anything. Why don't we do the next bill while you're up here? Just go ahead and we'll trying to be efficient. So
Sure thing, Mr. Chairman. The next bill, 22 LSO 219, working draft 0.4. This was also came out of that same discussion at our September meeting, with the idea that the last time the committee did a bill on reporting, then there was a lot of question as to what the tax might look like. And so the idea was to give an example of what the tax might be, with the idea that it would not be effective until July of 2025, and would exempt the first $4 million of taxes. There was not a lot of additional direction to the committee, from the committee, and it was more the idea of a kind of a placeholder to get an example of what this tax might look like, Mr. Chairman. Had discussions with Representative Obermuller, had done a lot of work in this area, and he presented to the committee last time. We based this bill on Nevada's tax. So we did do the exemption of the first $4 million. We put in a 1/4% tax rate, and the tax is overall distributed like the sales tax. I don't know how deep you want to go into this, Mr. Chairman. It's definitely I it's
suspect a very high level is appropriate.
a high level, Mr. Chairman. So
Okay.
as I will note, first, starting on page 2 is the definition section. All these definitions come from Nevada's tax. certainly a lot of policy choices in here, Mr. Chairman. The biggest one in the definitions likely is two major ones, but the definition of business entity, starting on page 2. You'll see it. It's a corporation, partnership, proprietorship, limited liability company, business association, joint venture, limited liability partnership, business trust, professional association, joint stock company, holding company, and any other person engaged in the business, which is also defined later. Then there are certain exemptions, people that are, the state is prohibited from taxing, natural persons with some exceptions to that exemption, governmental entities, tax exempt organizations, nonprofits, credit unions, grantors of trusts, the estate of a natural person, real estate investment trusts, real estate mortgage investment conduits, and then trust defined under 26 USC 401, passive entities, et cetera. Continuing on, Mr. Chairman, again.
Mr. Chairman.
I think-
Representative Baker.
Thank you, Mr. Chairman. Josh, we removed DAOs from the other bill. Where would DAOs be captured in this bill in any definition? Thank you, Mr. Chairman.
Mr. Anderson.
Mr. Chairman, not specifically addressed in this definition that I'm aware of, Mr. Chairman. So something we'd want to consider, Mr. Chairman.
Okay. Anything else? Keep going.
Sure. Mr. Chairman, then again, another important definition on beginning on page 7 is definition of gross revenue, which is of course what is going to be taxed on. I'll kind of let you guys look at that. You know, again, there's a lot of policy choices in here. And certain exclusions of that beginning on page 8. So cash discounts, goods provided on a complimentary basis, and other exclusions. Those are the main definitions, I think, that are of concern. So continuing over to page 17, Mr. Chairman, one question here. Nevada defines taxable year as beginning on July 1 and ending on June 30th. As I walked through the bill with Representative Obermuller, he suggested it might be more appropriate to have that be a calendar year. So just wanted to point that out for your consideration. Then, Mr. Chairman, the definition of Wyoming gross revenue, which is what the tax actually applies to, is gross revenue, bottom of page 17, adjusted pursuant to 3924-103B, which allows for some deductions, and then citus to Wyoming under 3924-103C, which is the allocation procedure. And again, that's taken primarily from Nevada's law. Over to page 18, Mr. Chairman, the administration and confidentiality provision. That provision is not from Nevada. It's consistent with the previous gross receipts tax that was looked at by this committee and is based on existing Wyoming law and our other tax code chapters. So won't get into that deeply, Mr. Chairman, unless there's any question.
I think you're good.
Over to page 22, the imposition section, Mr. Chairman, just applies the tax for the privilege of doing business in the state. In computing the business tax, certain deductions are allowed from gross revenue. You can see those there on beginning on the bottom of page 22. Again, some of these are a little duplicative with the definition, but it's gross revenue that the state's prohibited from taxing, dividends, interests on bonds from the federal government or state of Wyoming. Certain healthcare payments are excluded on page 23. Page 24, there's exclusions for employee leasing companies, pass-through revenue, The tax basis of securities and loans is excluded. Order page 25. Leasing of certain entities or certain facilities by the federal government. Interest income, dividends and distributions, and income from pass-through entities. Certain exchanges at the bottom of page 25. Hedging transaction receipts at the top of page 26. Repayment of loans on the bottom of page 26. And again, another loan at the top of page 27. Issuance of stock, payments from insurance policies, damages from litigation, bad debts. Over to page 28, accounts receivable to the extent they're included in the underlying transaction or already included in the gross revenue, basically, Mr. Chairman. And then the net income of a passive entity if it's generated by another business entity. On the middle of page 28, subsection C, this is the what Nevada calls the citusing, or what was previously, I believe, in our gross receipts bill was discussed as allocation, but just determines what amount of the revenue is allocated to Wyoming. So, Mr. Chairman, bottom of page 28, gross rents and royalties from real property located in this state and sale of property located in this state. Rents and royalties from tangible personal property if it's located in this state. Property sold that is delivered or shipped to a buyer in this state. Transportation if the origin and destination point is in this state. Services is based on the benefit or where the purchaser receives the benefit compared with any benefit received outside of the state. And bottom of page 30, Mr. Chairman, if it's not otherwise described, it's citus if the business is conducted in this state. And subsection D, top of page 31. Again, it allows the department to use other citusing rules if necessary to fairly represent the business conducted in the state. Page 31, 39, 24, 104, sets the taxation rate. Again, you see there the exclusion of the $4 million that applies to the greater of the Wyoming gross revenue or the Wyoming payroll of the business entity multiplied by 0.25%. Mr. Chairman, going over to page 32. This is all fairly common with our other compliance and collection procedures and other chapters, with the exception of subsection A, which allows business entities that don't have payroll or revenues over $4 million to not report. I believe Representative Obermuller had some suggestions on some revisions to this section, but just wanted to highlight that. The rest of that section is pretty standard language. Same with the enforcement section, Mr. Chairman. Again, that's all pretty common with our other tax chapters. That continues over to page 39, the taxpayer remedies. Again, this section is similar to what we saw in the gross receipts tax and consistent with our other provisions. You'll note there on page 41 that the taxpayer gets a credit for all excise, sales, use, severance, and ad valorem taxes paid in the taxable year by the same taxpayer. Again, that's the same kind of credit that we had discussed with the gross receipts tax. I wanted to point that out. Over to page 42, statute of limitations. Again, that's fairly consistent language. The distribution on page 43, Mr. Chairman. This, as I noted at the beginning, is based essentially on the sales tax distribution. So 69% will go to the state. And then the remaining share get distributed out to the local governments based on where the tax was collected, and then within each county based on the population of cities and towns. Mr. Chairman, over to page 45. Requires the Department of Revenue to adopt rules not later than July 1 of 2025, which is when this bill would, or when the tax would go into effect. Again, that could be adjusted to a calendar year if that is the direction of the committee. Requires the department to report any recommended statutory changes, appropriations, or other resources necessary to implement the tax to this committee. Initial report not later than July 1 of 2022, and a final report not later than July 1 of 2024 with their proposed final rules. That's the bill, Mr. Chairman. Take any questions.
Thank you very much, Mr. Anderson. I thought you did a nice job walking us through that. Questions for Mr. Anderson at this point? Any questions? Representative Sweeney, was that you?
Yes.
Go ahead.
Thank you, Mr. Chairman. So, Josh, on page 31 on the taxation rate, in House Bill 64, my recollection is that we were suggesting a 7%, not a quarter, and then did that particular bill in 64 have a threshold like the 4 million that had to be reached?
Mr. Anderson, if you can.
I don't recall specifically if there was a threshold amount in that, Mr. Chairman. I do believe you're correct that it was a 7% rate that was in that bill. This 0.25% rate was suggested by Representative Obermuller. Nevada has various rates for different NAICS codes in their bill, ranging from very low, much lower than this rate to higher than the 0.25% rate, but we settled on that rate as a starting point.
Right, and Mr. Anderson and Representative Sweeney, I think we have to remember the basis for assessing this tax is different than the tax in 64. This is a gross receipts tax. The other one was a straight corporate income tax. I won't call it straight, but it was a curved corporate income tax perhaps. So they're different animals. This is on, there's a lot of finesse in this, but it's technically on the total amount of money you make that's jurisdictional in Wyoming, you pay 0.25% under this bill. The other one was about the net. So how that quarter relates to the 7, I'm not actually sure I know, but they're kind of the different basis for the taxes. I think we probably should keep that in mind a little bit. In theory, I think the gross receipts piece is a little easier to implement, but we'll hear from Representative Obermuller about this more, I'm sure. Did I characterize that as correctly, Josh, do you think?
I believe that's correct, Mr. Chairman.
Thank you. Anybody else? Representative or Senator Schuler, I don't know why I'm doing this representative thing. QRS, I guess.
Thank you,
Senator
Mr.
Schuler.
Thank you, Mr. Chairman. No problem there. I had a question on the $4 million, the cutoff there. I realize you've used Nevada's, their exemption, or excuse me, their gross revenue bill, I guess, as kind of a model. Do you have any idea how many companies this would affect in Wyoming in terms of small companies versus big companies? Has anybody done any research on that?
Mr. Anderson.
Mr. Chairman, Senator Schuler. No, I'm not aware of that. I think that's part of the purpose of the first bill we talked about is, we don't have a lot of information on, what this tax might do. And so that other bill, it's an attempt to figure that out. The $4 million did match what Nevada did.
Anything else, Senator? Senator James, did you have your hand up? Okay. Anybody else? Anybody else online? Okay, can we start with Representative Obermuller? Would you be? Don't go too far away, Josh. Representative Obermuller, I'm sure you noticed we're kind of taking both bills together, trying to be expedient, but.
Yeah, thank you, Mr. Chairman. I would like to just address I think the first bill is pretty self-evident, gathering information. I just want to address the second bill, if that's all right, Mr. Chairman.
Perfectly okay.
And I believe that this bill is the beginning of the discussion to promote this as a bill that the committee should take up for this session. I think it's premature. In our previous discussions about other corporate bills, it became evident that it makes sense to have more tax minds, more legal minds, look at the language of these bills so that we can hold up against the attorney or the lawyers that are brought in to oppose it. I felt like, in the past, it felt pretty underqualified to confront the legal minds that were challenging the bill. So I think the bill itself needs that kind of scrutiny. We don't have time for that. What this bill does that's different than in the past is set some benchmarks. I think sets some placeholders for the discussion in the future. I think in the past, when we haven't had enough clarity as to what the bill called for, there was a lot of speculation as to what it would be. So this one sets some markers. It's based on Nevada, but there's other states that are similar to us that have different regimens. And I think that's also part of the future discussion. The states that I'm referring to, particularly Texas and the state of Washington, also have this type of tax. And they also do not have a personal income tax. So we're looking at some type of regimen that would be, the comparative states are the ones that are trying to navigate not having a personal income tax. So that's my overall view of this, Mr. Chairman. I do have a couple of minutes of commentary on why I'm bothering with this at all, with your permission, Mr. Chairman.
Absolutely, go ahead.
The question is why this bill? And over the last few years, I think it's become clear that many who favor the broadening of our tax base have come to prefer expansion of our sales tax approach, evidenced by the work on eliminating sales tax exemptions. This bill incorporates the concepts of an expanded sales tax in a little different fashion, but it's similar in important ways. First, it's essentially a pass-through tax calculated in the same way as sales tax, essentially. If you think of this as another form of sales tax, it helps clear the fog of the arguments of those interest groups that will testify against it. So they will, there's all with any tax regimen, there's always the objections that come up about the fairness between different companies or the effects it causes in one way or another. So if the focus is on how our sales tax currently works, and if you think of this type of tax as essentially an extension of that, then I think we can get past some of the objections that will come up in that kind of testimony. Second, from an administrative perspective, the collection process could be joined to the current system of collecting sales and use tax. So not confronting the issue of broadening our tax base really comes with a price in this state. Currently, we're locked in to a cycle of dependency on federal revenue, which is our largest source of income, the energy sector, which is the only business source of income, and the global economy, which depletes our capital base every day by electronic transfer. Even super funds have the potential to create dependency if viewed as our long-term plan to replace severance taxes. Reasonable tax policy is what we do as a society in order to create the conditions for people and businesses to survive and thrive. Without creating the necessary conditions, it's just sagebrush, as my friend and representative from Afton, Wyoming once said about the water bill in trying to fund water. He said, without water, it's just sagebrush. And I thought that has some general application in this state with many of the things that we do. So why this bill as an alternative to just increasing sales taxes if it's the same thing? Besides broadening the tax base, this tax regime has other advantages. Any substantial business in Wyoming is eyeing revenue in other states in the world. They're not looking to come to Wyoming to sell product in Wyoming. They're looking to sell product other places. This bill takes this into account by factoring in payroll as a measurement tool as well as revenue. This bill allows for a lower rate for the same revenue impact as sales tax, same revenue impact as sales tax because it broadens the scope over a much larger range. I mean, one of the objections to this as well, companies will just vertically integrate to avoid paying the tax. And I say, fine, let's do that. You know, I mean, business, we all have the right to limit our tax exposure. And if integrating some economic sector vertically is the answer to this, I say go for it. I don't think it changes the nature of this idea at all. Exemptions are defined in this bill by financial measures, whatever that is. Right now, the $4 million is the placeholder here, but it could be something else. Under the sales tax regimen, it's defined by NICS codes, by company type, and it makes it really difficult, as you know, to make any movement in that exemption area. In this particular style of sales tax, the exemption is based on financial measurements, and it's a lot easier idea to apply across the board. Under the franchise tax, a business can decide on their own whether to pass this cost on to customers. Currently, the economic effect of customers making the buy or not buy choice are borne solely by the retail industry. When we hear this story, right, that the choice can be made by the consumer if to buy or not buy. So when you put in a sales tax, the customer can decide whether to pay the tax or not, buy or not buy, right? So that decision process, which can lead to a not buy decision, is borne by the retail industry exclusively. So having the retail industry bear the burden of a sales tax increase, where you can use a smaller rate and spread that burden across the population, makes a lot of sense. One of the most intriguing differences that makes the franchise tax attractive compared to sales tax is the manner in which this tax is accounted for by the global economy. With your permission, Mr. Chairman, I would like to have a little handout.
Sure. Can somebody help him with that? Dean's behind you. He'll help. Did you bring any extras for our crowd? Maybe.
There might be a few extras.
It's always good to let the public know what we're doing, you know. So if people want to share up here and make some available to pass around back there, that'd be fine.
This is falls in the category of fun fact, Mr. Chairman.
I think you'd be. So for the people online and the crowd, it's a really simple it's a receipt from a private company. It's a sales receipt. So maybe you can describe it so that folks can see it.
Okay, Mr. Chairman, this is a copy of a bill from someone I know in Washington State. They did some shopping for me to create this bill so we could see what a bill looks like in the state of Washington when you go to a major global store. And so this is it. And you see it's a variety of things, including food items and non-food items. And you see that as you come down to the bottom, which is what the attention I want to bring you to, there's a bag tax of 8 cents. Then a subtotal. Then there's a 10% tax. What that is the combination of Washington's state sales tax and their local sales tax for this town. You can see the town location at the top. Now, the thing that you don't see on this bill is that Washington has a gross receipts tax. So where is it? The answer is it's in the cost of these goods. And we've had this discussion before in the topic of business taxation, is that the global economy uses the big bucket approach to taxation. We all share in that cost of corporate taxation. 48 states tax corporations, and the cost of that gets dumped into their cost of goods. So the point I want to make about this is who is paying that corporate tax? Their citizens aren't paying it directly. We are all sharing in that. So the tax that was paid on this sale, Wyoming citizens are paying their proportionate share of that through a system called standard pricing, universal pricing. You know how that works. When you go into these stores, you can buy the same thing here as you do in New Jersey for the same price. So we're all caught up in this system of paying the taxes that these companies pay through their pricing and how they price their products. It's important to know that, because if Wyoming institutes some kind of tax regime like this to capture those dollars.
I see your hand is up. I'm waiting for the witness to get to a point. I'll ask him if he wants questions at the end or not. So I do see your hand is up. Let the witness finish.
So the implication for a Wyoming customer is we have similar kind of bills in this state as this one. You come down and you have in the county that I'm coming from, that's going to be a 5% rate. If we had a gross receipts tax, franchise tax, whatever you want to call it, it would not be on that bill. It would be thrown into the big bucket, the national bucket. And the amount that a Wyoming citizen would pay is a minuscule amount. I mean, we've done some calculations that show it just virtually disappears in terms of a added price to the product because of the way it's spread. So as the global economy becomes more and more influential in our state, we need to confront the issue of the global economy and how it impacts us. So that's part of the discussion that takes us into the future, one of the more intriguing places. So that basically completes my testimony today, Mr. Chairman.
Okay, thank you very much. Let's get Senator James's question first.
Thank you, Mr. Chairman. So do you have a Wyoming receipt with these same items so that we could have a comparison?
Representative Obermuller.
Yeah, thank you, Mr. Chairman. I wish I had thought of doing that, but I don't. Our bill from this same company would have, in my county, would come down. There wouldn't be any bag tax, but you'd come down to a subtotal and then it would show a 5% sales tax.
Go ahead, Senator James.
I was talking about like the items, so that way we could see if what you were saying about the cost being put into the actual items was accurate. So that's what I was referring to.
So like the baked beans, would they
Yes.
be the same price in Wyoming as in Washington? And if I recall from previous discussion, you actually had provided some analysis about the cost of, I believe it was a television set, if I remember right. in
Right.
A previous iteration of this concept, but answer the question if you can.
Right, Mr. Chairman, that is a fair question. That was part of the analysis when we were doing this before, is to do some comparative look. But now that everybody has this, I suppose you can go to your local store and check out these prices compared to what's showing on here and find out if there's any truth to it or not.
So now you think my good co-chairman is playing around on the internet right now. And you're kind of right, except for he's pulled up Walmart on, oh, I'm so sorry. He's pulled up this large retailer's website online. And we're going to contest the raspberry Jello. We're just right here. We're just flat going to contest it. You're totally wrong. Raspberry Jello in Washington State may be $100 or $1.16, but raspberry Jello in Casper, Wyoming is $1.22. I want you to know.
Mr. Chairman, if I
Go ahead.
may, in the earlier discussions about that with this particular store, we learned that there is some discretion with store managers based on competitive prices in their area. If they need to take on somebody that's dropped a price on them, or they have an opportunity to make a little bit more because prices are higher, they do have that kind of flexibility as a modification of the general pricing model.
Okay, back to you, Senator James. Okay. Anybody else? Representative Roscoe.
Thank you, Mr. Chairman. Representative Obermuller, so I might be wrong on this, but in a sense, if we're buying file folders here, we're already paying a corporate tax on that, or we're already sort of paying this tax to a company that's a global company or a company that's out of our state, but and yet we're not receiving any tax revenue. Is that close?
Representative Obermuller.
That is exactly the point. I think we, in a sense, have a fiduciary responsibility here to bring some of that money back to Wyoming that our citizens invest in other people's taxes.
Let the record show that the beans, baked beans at 218 in Washington State are identical to the same baked beans in Casper, Wyoming, from this very large retailer. Back to you, Representative Obermuller.
That's it, Mr. Chairman.
Okay, questions for Representative Obermuller? Representative Sweeney.
Thank you. Thank you, Representative Obermuller, for all your work and continuing on this. So we're not in this example, obviously we're picking out one company, but we're talking much broader than this one company. And this is just an example, but we're trying to talk about the space in all industries, and all, whether it's retail or not, in this regiment, what have you. But in this bill, you know, as you've stated, it's not ready for prime time. So would your belief be to try, and I've got some questions for you on the reporting bill, but on this bill, try to keep this moving in the next interim as an interim study for this committee. Is that kind of your thought process?
Mr. Chairman.
Representative Obermuller.
Thank you, Mr. Chairman. Representative Sweeney, that's exactly what I would like to see. Previous efforts at this, what if you put the topic off and then deal with it late in the year next year, then it has the same problem of just being dumped on, right in the face of an upcoming session. So we need to have a longer discussion about it. We need to be able to do comparisons between Nevada, Texas, Washington, or any other state that's doing this. We need to wordsmith the bill. We need all those things. So that's exactly right. Thank you.
Okay, here's the update. File folders, $4.28 in Lakewood, Washington. Casper, Wyoming, $4.28. Identical. So go buy your file folders locally. Anyway, anything else for Representative Obermuller? Mr. Co-Chairman.
Thank you, Mr. Chairman. Representative Obermuller, thank you for all your work on this. You put unseen hours, and you have your special qualifications with your training and background and dealing with interstate commerce. And so I appreciate your expertise in this area and your work. Really, my question's on the reporting bill. And I understand, I think I'll move to table the tax bill and continue to work on that. And but my question really is on the reporting bill. You feel the same way about the reporting bill? And I guess I want to ask you, because this was kind of your area, how onerous is this bill if we pass this reporting bill? Is that a hard thing for folks to comply with? Thank you,
Mr. Chairman.
Representative Obermuller.
Mr. Chairman, currently there's an exhibit that companies have to prepare for the Secretary of State that demonstrates what your assets are. When I was in the accounting practice and assisted in filling out these forms, the place that we went to get that information is the same place I would go to get the numbers on payroll and gross revenue. So the people that file, or the companies that file with the Secretary of State, are already disclosing their asset base. We're asking for a couple additional items from the same source that information was drawn from. So I don't consider it to be an onerous issue on the reporting side as far as what businesses would have to do.
Anybody else? Senator James?
Thank you, Mr. Chairman.
And then we'll go, I see you, Dr. Hallinan. We'll go to you next after Senator James.
So currently, the government is the #1 employer of Wyoming, which does not produce revenue. Do you see this attracting private sector businesses to Wyoming, which would produce revenue? Adding a corporate tax does not seem attractive to me in attracting private sector businesses. So do you see this type of legislation attracting private sector businesses?
Representative Obermuller.
Honestly, tax policy is down the list of criteria for companies making a choice about where to locate. The Texas model, which includes a gross receipts tax, hasn't stopped that state from growing exponentially. But there's another part of this question and answer, Mr. Chairman, if I might. When in my remarks, I said that one of the roles of government is to create the conditions that make it possible for people to survive and thrive, including businesses. And that role of government involves tax policy. When you depress your tax collections, you also depress the effort to create those conditions. And in Wyoming, being a rural state, that's a formidable task with our water projects, with our road projects, with our schools, with rural health. See, we have a choice in Wyoming, Mr. Chairman, of either retreating to take Wyoming off the grid, so to speak, and become extremely rural again. Or we can move forward to be a modern rural state. And my sense of it is that the people of Wyoming want modern rural, not regressive rural. So that takes reasonable tax policy. And I think that this bill fits into that philosophy. Thank you.
Thank you, Representative. Anybody else? We'll go with, I promised Dr. Hallinan, you guys, if you remember. So Dr. Hallinan, we'll get you next.
Thank you, Mr. Chairman. I have a question on page 9 of this bill under VII. It says healthcare institution means a medical facility or a pharmacy operated for profit. Now, does that mean that this franchise tax is going to apply to a group of physicians in a medical group, which I don't think would be that unusual for a large group to have $4 million in gross receipts? So would that apply to them, the tax?
Representative Obermuller.
Mr. Chairman, precisely why this needs to be an interim topic.
So I'm trying to roll this backward. It's Romanet 8. Romanet.
Page 9.
Yep. It's a standalone definition, I think, is what that is. It doesn't say whether it's applied to or not, but it's in the definition section. Josh, can you help me with how it's later used or how it connects?
Mr. Chairman, yeah, so it's used later. So certain healthcare payments are specifically excluded from gross receipts later on. So Medicaid payments, et cetera. So the implication, I guess, is that it would apply likely to those types of entities in Nevada anyway, and if this were to pass here, but that certain types of payments that those healthcare facilities receive would be excluded from gross receipts. So Medicaid payments, uncompensated care, and I think one other thing. I couldn't find it in a real quick look, but anyway, Mr. Chairman.
Thank you, Mr. Anderson. All right, now to Representative Sweeney and then Mr. Co-Chairman.
Mr. Chairman, just as I'm reading the last question from Doc Hallinan, page 8, line 9, it says B does not include, and then that's still referring, I believe, over to page 9 for what? So, but
Representative Sweeney, let me try to help you with that. I think B, all the larger Romanet letters, capital Roman letters are under B, and that takes it down to capital Roman 7 on line 16 and 17. Those are all under B, but lines 19 and 20 are not under B. So it's a weird thing that we use. We actually use the Romanets are a higher section of the statute than the large Romanet, and it's just a convention. Go ahead.
thank you. So back to the reporting bill. So I'm a flower shop in Casper, and how onerous do you think they'd be under 4 million, most likely. Would they necessarily have to report, or would it be zeros in that section if we're able to get the reporting bill through?
Mr. Chairman, can I grab a lifeline on that one with Josh?
Yeah, so did you understand what?
Sorry, I missed the question, Mr. Chairman.
Okay, here's the gist of it. I think if you had a business that was under the $4 million threshold, so that they wouldn't have a tax obligation under the tax implementation bill, are they still required to report under the reporting bill?
Yes, Mr. Chairman. There's
Okay.
not a current exemption in the reporting bill other than nonprofit organizations as of right now.
Thank you, Mr. Anderson. Does that help you?
Yep.
Okay, Mr. Co-Chairman, we're good for now? Okay, any other questions for Representative Obermuller? Representative Yen.
Thank you, Mr. Chairman. So I think I just want to follow up on Senator James's question on tax policy. And I'm curious on whether you think the unstable revenue that we currently have in Wyoming, where we are in boom bust cycles, if that attracts private businesses, or having a stable revenue source where we can ensure continuity of services is better for the environment that you're talking about, where private businesses are interested in having a situation where they can succeed in Wyoming. Thank you, Mr. Chairman.
Representative Obermuller, if you can.
Mr.
I
Chairman.
think it was a softball, Representative Obermuller.
Yeah.
I really do.
Right, I'm trying not to hit a foul ball here. I think everyone knows by now that my position is that the discussion of tax policy is part of the effort to stabilize our revenue sources so that we can meet our obligation to create the conditions necessary for business to survive. It's a critical component of it. Every other method leaves us totally dependent on something else. So thank you, Mr. Chairman.
Thank you, Representative Obermuller. So Senator Schuler.
Thank you, Mr. Chairman. Yeah, just to kind of tag along, I think with Representative Yin, if you look at the state directly to our west, I don't know if I should, can I mention states today? Probably not.
Actually, you can.
I can,
In the-
okay.
In committees, you can
Good.
actually use proper nouns. We
Okay.
can even use business names and
Perfect.
personal names. It's not always a great idea. So the business we were talking about before, sometimes politeness says no, but you can certainly refer to the
Okay.
policy of any state.
Well, we'll just say Utah then. Again, we're a border city where I'm at, and a lot of folks over in my neck of the woods, they run across the border and they pay, of course, higher sales tax. They have both gross receipts and corporate tax over there, and they're growing. They're one of the fastest growing states. I think if you look at them, I think you look at Texas and you look at Florida, they're the fastest growing states, and they all have gross receipt taxes and corporate taxes. The only two states I believe that don't have the gross receipt are us and South Dakota. So obviously, I think if our state is to grow and to flourish, and many of those states don't have the extractive industries that we have, I think we have to expand. Can you talk a little bit about how you think it might help our state to kind of grow and flourish a little bit if we had something like this, versus stagnating and leaving our tax base as is?
Representative Obermuller, I'm not sure, but I think that was a friendly question too.
Thank you, Mr. Chairman. I think it's a critical part of it. When you go back to what I said earlier about what the expectations of Wyoming citizens are, I don't think it's regressive at all. You hear a few voices, that want to move in a different direction, but I think most people want modern rural. So what does modern rural look like in relation to that government-private partnership? I think the role of government is to help create the right conditions. So just one, there's really two really great examples, and that's water development and roads and infrastructure. If we want to attract businesses to this town or to this state, that they need to see that kind of infrastructure is here, and that we take public education seriously, and that we have access to healthcare. All those things where private solutions really do not exist. The role of government is to step into those places where private solutions do not exist and create those conditions. And that's why we get together. We throw our individual money into a hat so we can do for each other what we can't do for ourselves. It's the nature of government, and we need to take control of that piece for ourselves. Thank you for the question.
Trying to get my mic to work. Thank you, Representative Overmuller. Anybody else? All right, let's hear from other folks about these two bills. As state agencies, Secretary of State's office, do you want to start? Perhaps on the reporting bill? Appreciate it. Welcome, Ms. Wheeler.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Co-Chairman, members of the committee, I'm Karen Wheeler, the Deputy Secretary of State, and I am here to speak on the reporting bill. And Mr. Chairman, if I may, I would first like to thank Mr. Anderson for coming to our office and sitting down with me and going over the concept of this bill. I threw a lot of information at him, and I'm probably the cause of the confusion on page 2, subsection C. So, Mr. Chairman, the Secretary of State's office can implement this bill by the effective date. However, to implement it, there is a fiscal impact to our WyoBear system. And Mr. Chairman, I'm happy to go over the modifications that would need to be made to the system if you would like.
Absolutely. Go ahead.
Okay, thank you, Mr. Chairman. So the Secretary of State's office has 11 business entity types that file annual reports with our office. So the collection of this information would require the changes to our WyoBear system, and WyoBear is our acronym for the Wyoming Business Entity Annual Report System. First, we would have to modify the back-end data structure and our online annual report and reinstatement filing wizards. Each would require an annual report worksheet modification to add the 4 additional pieces of information to be collected. Now, for any annual report that is being filed for which the due date is 60 days prior to July 1st of 2023, our system would need to know that the entities do not have to file the information because it's before the effective date of the bill. Our system would then know for any annual report filed after July 1st of 2023, the information must be collected. Of the 11 entities that file the annual reports with our office, and I believe this is where the confusion came, 3 pay a flat fee and do not fill out the worksheet. And so, Mr. Chairman, those 3 are the nonprofit, statutory trust, and statutory foundation. So our office would need direction as to whether or not they should file a worksheet and list not applicable. If that's the direction to go, then our system would automatically populate not applicable on their worksheet. Or if you want to leave it as status quo and they do not file a worksheet, we would need direction on that. Additionally, Mr. Chairman, we would need to modify the reinstatement process. So when an entity files with us, they have to file an annual report once a year. After multiple notices that their annual report due date is coming up, and these notices come from our office, if they do not file their annual report, our office administratively dissolves the entity. Now that entity has 2 years to reinstate or bring it back to life. So, Mr. Chairman, we would need to modify our system so that if an entity was dissolved in 2021 or 2022, and they choose to reinstate in 2023, and if that reinstatement is before July 1st of 2023, the system would know to pull up an annual report for 2021, 2022, and the annual report before July 1st of 2023, and not collect the 4 pieces of information. Conversely, if an entity reinstates after July 1st of 2023, the system would know for that entity the 2021 annual report, the 2022 annual report do not have to collect that information, but the 2023 would have to. So when you reinstate and you put your entity name into our system knows for entity ABC, these are the reports that are due to be reinstated. So we'd have to modify it for those reinstatements. Mr. Chairman, additionally, we will be building a trigger into the system. 86% of annual reports are filed online with our office. So when they're filed online, we would build in a trigger that the new pieces of information, those 4 pieces, something must be entered before you can move on to the next step and file your annual report. Mr. Chairman, a new aggregate report would have to be created to run at an ad hoc basis, or we would run it monthly to collect the information required for your committee or the Department of Revenue. And then, Mr. Chairman, if the requirements of the collection of information are to be on a temporary basis, and after the committee or the Department of Revenue has sufficient information over a span of time, and we need to undo these requirements, there would be an additional fiscal impact to do that as well. So, Mr. Chairman, to implement this bill in our WyoBear system, the fiscal impact is $211,600.
Okay, thank you for that.
Yes.
Anything else?
No, Mr. Chairman, I'm happy to answer any questions.
Okay, thank you, Ms. Wheeler. Questions for Ms. Wheeler? Representative Sweeney.
Thank you, Mr. Chairman. So your fiscal impact estimate is 211,000, and that would include all the programming and all the back of the house type work to implement this.
Mr.
Ms.
Chairman,
Wheeler.
Representative Sweeney, the 211,600 is to implement the bill. There would be an additional impact to undo all of these changes, which would be $169,280.
Thank you, Mr. Chairman.
Thank you, Representative. Anybody else? Questions for Ms. Wheeler? Thank you. Thank you
Mr.
very
Chairman.
much. Department of Revenue, did you want us, you're going to hide out on this one? It's okay, perfectly okay. Would anybody else like to address the committee on either of these 2 bills? Would anybody else? Come on, I know you do. Anybody want to address? Mr. Pickard? That's what you get. You squirm more in your seat than anybody else out there, so I grabbed you.
Good morning.
Good morning.
Mr. Chairman, members of the committee, my name is Dave Pickard. I'm representing myself in this discussion here. I understand the intent of the reporting bill, and I'm just speaking specifically towards the reporting bill. I understand the intent. We've been down this road many times, but I would draw kind of a philosophical discussion out. Is it the role of government to obtain private information that they're not going to use except for their own purpose in the future to implement a tax policy? So I'd be very concerned about, I would certainly be under the $4 million, but it still, as drafted, require me to report that. And I understand the confidentiality, all of those safeguards in place, but we also had those safeguards in place in the Department of Health. And over 80,000 records were divulged to the World Wide Web. So my concern would certainly be the collection of the data for no specific purpose that results in anything other than future legislation or perhaps future legislation. With that, I'd stand for any questions.
Thank you, Mr. Pickard. Questions for Mr. Pickard? Anybody online? Thank you, Mr. Pickard. Thank you very much. Who else would like to address the committee on either of these two bills? Representative Yen, I'm sorry.
Mr. Chairman, Brett Moline is online with his hand
Okay.
raised.
Thank you. Just holler at me, you guys, and get me straightened out. Mr. Moline, would this be a good time for you? I can't imagine what you're going to say. Mr. Moline, while you're trying to get on, there you are. Welcome. It's good to see you. Well, you're muted. We can't hear you.
Okay, is that better, sir?
Perfect. Thank you.
Okay, sorry, my technology is still new to a redneck. Mr. Chairman, Brett Moline, Wyoming Farm Bureau, speaking against the concept of a gross receipts tax. That is something my members do have policy against, is a gross receipts tax. Agriculture is one of probably the few industries that cannot pass this tax on to the buyer of their goods. Being in the perfectly competitive market, we just have to eat the taxes. Granted, very few of my members would reach that $4 million threshold, but that threshold is just a line on a paper that could be raised, but it could also be lowered. Should these bills go forward, I can't speak in favor of them, but if they would go forward under the reporting bill, right now it would be under the calendar year, and I would suggest making that reporting, should the bill go forward, that it would be based on the fiscal year of the business entity. Given that many businesses don't operate on the January 1 to December 31st year, if that could be changed, so it'd be reported on the fiscal year. But again, not supporting the bill, but if it would go forward, like those changes and against the concept, and I've talked long enough, Mr. Chairman, I'd sit for any questions.
Thank you, Mr. Moline. Questions for Mr. Moline? Representative Roscoe.
Thank you, Mr. Chairman. Mr. Moline, I'm just curious of what was brought up earlier about the benefits of government providing for water and highways. The agriculture community, I know, has an opinion on it. I was just wondering how you feel about that. Thank you, Mr. Chairman.
Is the question, how do they feel about water and highways? The benefits of water and highway, if I understand, Mr. Moline.
Mr. Chairman, Representative, we appreciate the benefits that we have based on a study that Dr. Taylor did up in the Ag Econ department. Agricultural land more than pays for the cost of it, of the government services that we represent, that we use. So essentially, hate to use the word, we're a profit entity for governments based on the taxes that we pay, and the services that we receive. We appreciate the benefits. We understand the benefits. We use them. And so we do appreciate them. I hope I answered your question, sir.
Follow up or anything? And Mr. Moline, you mentioned a study by Dr. Taylor. I think I might, when was that study provided to the committee? Or is that something?
Mr. Chairman, I don't know if that study has not been provided to the committee. It was probably done way last century, but I will try to find if I can get a copy of it and get it forward to the committee and LSO.
Thank you very much, Mr. Moline. We sure appreciate it. Anybody else question for Mr. Moline? Representative Sweeney has a question.
Thank you, Mr. Chairman. So my question is, when you mentioned fiscal year, this is basically goes back to filing your federal taxes and tax report, and that's where you gain the information from. So how would that, when you made the comment about the fiscal year, how does that actually relate to the bill?
Mr. Moline?
Mr. Chairman, Representative, the way I understand the reporting bill, it would be the information submitted to the state would be based on a calendar year. And so my business entities that are running on a different fiscal year would have to do another calculation to get it based on the calendar year rather than on the business entity's fiscal year. It'd be one more burden that they would have to come up with. Any other things with the federal income tax reporting is always based on the business entity's fiscal year. Perhaps I misunderstood how that bill under the reporting bill, how that line is written, but I thought I heard that it was going to be based on the receipts would be based on a calendar year rather than a fiscal year.
I'm trying to think this out a little bit, and I'm wondering if Representative Obermuller can help us with this, or possibly the Secretary of State, or Josh. Mr. Anderson.
Mr. Chairman, if you look at.
We can't, I don't think we can hear you. You got to get
Mr.
closer.
Chairman, if you look at page 2, line 5, it's information from the immediately preceding tax year. So it would be based on the tax year of the entity and not on any other specific fiscal year.
So, Mr. Moline, did you hear that?
Yes, Mr. Chairman, I did, and I sit corrected.
Okay, thank you, Mr. Moline. Anybody else? Questions for Mr. Moline? All right, thank you very much, Mr. Moline.
Thank you, Mr. Chairman and committee.
Who else would like to address the committee on this bill? Anybody else in the audience here? Anybody else online? And it's actually 2 bills, so it's both the reporting bill and the implementation bill. So anybody else? I'm not seeing any other testimonies. So committee, back to you, Mr. Anderson.
Mr. Chairman, before you try to take any action on this bill, just wanted to go back to the first bill.
The quorum issue bill?
Yeah, so.
Go ahead.
The rule would be that a majority of the quorum could take action. So
Okay.
with a 6-5 vote, that bill would have passed the.
I stand corrected. So that bill did pass. And understand the issue. And I mixed up a bill to pass the legislature has to be by all those elected. That's not the same standard that applies within the committee. It's a majority of a quorum. Majority of the quorum did pass that bill. So thank you. So that bill did pass. Thank you very much, Josh. And I apologize for the error. I think like a boy like me ought to know better after all these years. So it's a senior moment. Let's hope they don't happen again. Okay. Back on either one of these bills. Committee, you've heard the discussion. I don't know if there's any discussion you want to have preliminary, but Mr. Co-Chairman.
Mr. Chairman, I'd move to lay on the table the House Bill on Business Franchise Tax 22 LSO 219, just to lay that back to the interim.
So would your motion specifically be to have that be an interim topic?
Well, and I think we can discuss that later, but the motion is to lay on the table to the next interim.
Okay. You got a second? Technically, a motion to lay on the table is a non-debatable motion. It takes precedence over other motions. I'm not seeing that people want to talk much. Who's on the bill? We've got Representative Gray.
Yeah, Mr. Chairman, I just want to note I am here, so.
Great.
Thanks.
I hope you're not driving and looking down like that.
No, I'm not.
Okay, thank you. We're glad you're here. Thank you very much. So the motion is to table. All those in favor of the motion to table, I guess it's a final disposition. Do we need a roll call? What's your thoughts? Simple majority? Okay. It'd be a majority. All those in favor signify by raising your hand. I got keys by Representative Gray. They only count 1 vote. Got everybody on screen. Looks like it overwhelmingly is tabled. Okay. Is there a motion on the other bill?
Mr. Chairman,
Representative Sweeney.
I'd like to move 22 LSO dash 0218.
Thank you, Representative Sweeney. Is there a second? I got a second by Roscoe. Discussion. Any discussion? Are there any amendments? I know that one area that we need to fix, and Ms. Wheeler's helped us with that, or at least to point it out. It's on page 3. At the appropriate time, we need to deal with that language, lines 11 through 18. So are there any amendments on the bill? Ms. Wheeler, do you think you could come forward, and would you be prepared to like help us say what you really want in there? Thank you. I'm grateful. And then we'll see if we can get somebody to offer that amendment.
Mr. Chairman, thank you. I guess in this section, I would address the 3 entities that file paying a flat fee, which would be your nonprofit, which is in here, your statutory trusts and your statutory foundations.
Okay, so Josh, can you think of a different way to say that? To get it simple? Stay with us.
Mr. Chairman.
Go ahead.
I think we could do it. I don't know if here's the best place maybe, but I guess we could do it here and say the rules shall provide that nonprofit corporations, statutory trusts and statutory foundations shall not be required to file the information under this.
Somebody writing that
section.
down? Is that acceptable?
Yes, Mr. Chairman.
I'd have to refine it in the session, but yeah. Okay, somebody got that wrote down? Josh, did you get that?
I think so, Mr. Chairman.
Okay. So that is a bill that no one, or that's an amendment that no one has offered. We'd be looking for that amendment. We got a motion by the co-chairman, second by Schuler. Discussion on that amendment? No discussion. All those in favor of that amendment signify by raising your hand. 2, 3, 4, 5, 6, 7, 8. I got 8. That's a majority of the committee. Thank you. We can vote for the opposed if you want, but it doesn't change the outcome. Thank you, Ms. Wheeler. Thank you very much. Thank you, Josh, for that. Any other amendments on the bill? Any other proposed amendments on the bill? On the reporting bill? Going once, going twice? Okay, let's have a roll call on 20.
Mr. Chairman, I'd like to comment on the bill, though.
Okay, absolutely appropriate. Representative Gray.
Thank you, Mr. Chairman. Appreciate it. And I will note, because I know we're on YouTube, I am not driving. Just don't have the background because I'm on my cell phone. I'm going to be voting no on this bill. I think these bills are really, I think it creates a lot of uncertainty. And I think this committee needs to look at revenue distributions. And I think this continued effort to look at this topic, and I think that's the message this bill sends, even though it is the reporting bill, is really damaging to the business climate. And I think it squanders the tremendous opportunity from our low tax rates. So I'm going to be voting no. Thank you.
Thank you, Representative Gray. Who else would like to address the bill before we vote? Representative Sweeney.
Thank you, Mr. Chairman. So I believe this is the opportunity to take a look at this, whether we're going to move forward as a state on broadening our tax base. If we don't have the information, we don't know if this is even worthwhile in pursuing. And so I am very much in favor of this. If nothing else, it's a minimal investment, in my opinion, on trying to gather the data to move forward or stop in the process. But I think Representative Obermuller, Mr. Chairman, made a lot of good points on the role of government and in moving the state in a direction. So I would encourage members of the committee to vote in the affirmative on moving this portion forward so we can take a better look. Thank you, Mr. Chairman.
Thank you, Representative Sweeney. Anybody else? Representative Jennings.
So I think the testimony that we heard from the one person non-government wise was that this is why would you do this if you didn't have plans further down the road? And those of us that have been here a while know that there are plans down the road.
There are. Let's be
And
clear
so-
about that. Yes.
And so I see this as the camel's nose under the tent. So I'll be a no.
Okay. That's apparently not a big tent, just a pretty small tent, apparently. Okay. Anybody else? Come on. Last furious statements or whatever. Let's do it. Anything else? Let's have a roll call, please.
Senator Baldwin,
No.
Senator James. Senator Pappas,
Excused.
Senator Schuler. Representative Baker. Representative Gray,
No.
Representative Hallinan,
Aye.
Representative Henderson,
Excused.
Representative Jennings, Representative Roscoe. Representative Sweeney. Representative Yin,
Aye.
Co-Chairman Harshman. Chairman Case,
Aye. I count seven.
that's what I have.
Seven aye, which should be a majority of the quorum. So that bill will be referred to, that bill as amended will be referred to the session. All right, let's take a break. And we will come back and pick up local revenue options, and it must be 10 a.m. So when you get back, and let's come back at 20 till, so 10:40. We'll start promptly. Okay, let's call the meeting to order. Folks online. Representative Yin, are you still online? He's coming in.
I am, yep.
We're calling the meeting back to order, and our next kind of subsection is subsection 4, local revenue options. We've got 2 bills on the local revenue options. One, Representative Yin, is one that we've added based on your request. So we'll let you present that bill if that's a good way to start. Do you mind?
Sure, 1 second, Mr.
Mr.
Chairman.
Chairman,
Okay.
Mr. Chairman,
Mr. Anderson?
I think the individual bill from Representative Yin is on tomorrow's agenda under the property.
I am apologizing. I'm mixed up. So Representative Anderson, you're going to be, I'm promoting you. Actually, you make more money. So Mr. Anderson, please. Sorry about that. Representative Yin, cut you. I was mixed up again.
Thank you, Mr. Chairman. Yeah, I'll speak on it as the time comes.
Where would I be without correcting nudges from all of you? Thank you very much. So Mr. Anderson. County optional real estate tax.
Mr. Chairman, yes. County optional real estate tax 22 LSO 220 working draft 0.4. This again was one that came out of discussions at the September meeting. This is a primarily based on a bill that had been brought several times by different individual legislators. I believe Representative Schwartz has presented it to this committee before and was the last one to bring it as an individual bill. It's the idea of a county optional real estate tax. Just to go very quickly through the bill, Mr. Chairman. Really starting on page 3. It would allow a county to impose a tax on sales of real property. It would have to be in specific percentages for specified purposes as provided in the proposition. It does require an election of the county to impose this tax. All of that language starting on page 3 and continuing on to page 4 and 5 is pretty consistent with the optional sales tax proposition language that's in 3915-203. Would note over to page 6, Mr. Chairman, the basis of the tax is defined to be the full actual consideration paid for interest in legal title or interest in real property. If it's a gift or is transferred with nominal consideration or without consideration, it's collected based on the assessed value of the real property. And in subsection C there, Mr. Chairman, specifies that the taxpayer is the grantee of the transfer. So it would be the person receiving the property or purchasing the property. Over to page 7, Mr. Chairman, the rate of the tax for any sale up to $1 million, the rate would be 0%. Any sale in excess of that, any amount of a sale in excess of the $1 million would be 1%. Bottom of page 7, Mr. Chairman, there are a number of exemptions to this. So, of course, property recorded prior to July 1 of 2022, including if it was filed somewhat after that, but pursuant to a contract that was completed prior to that date. Over to page 8, she wouldn't have to file or pay this tax for deeds filed to correct or supplement previously recorded instruments between tenants in common, between spouses, pursuant to a court order, if it's without consideration to or from a trust, transfers between parent and child on page 9, between corporation and parent or subsidiary corporations, transfers that are due to sales from payment or delinquent taxes, transfers conducted to county certificate of purchase or a sheriff's deed, transfers of agricultural land are exempted. exchanges of real property, the amount of the lowest amount of the property being exchanged is exempt, so you would only pay on the tax for the more valuable piece of property. Certain transfers that of real property that's exempt from property tax is exempt on page 10. Transfers of mineral estates are exempt. Transfers of real property for industrial purposes, leases, easements, and then transfers of real property on the Wind River Indian Reservation if either the grantor or the grantee is a member of one of the tribes. On page 11, real property transferred without consideration to a nonprofit organization. And then in the middle of page 11 allows the department to exempt other types of transfers that should not be subject to the tax. Mr. Chairman, bottom of page 11 is the compliance. So this is payable at the county treasurer of the county where the property is located. Again, based on the total price paid for the property or the assessed value if no consideration is stated or provided. Does require in the middle of page 12, the grantor and the grantee to sign on a form, a statement, say, providing the information necessary to assess the tax, provides that that information is confidential and makes it a misdemeanor to disclose that at the bottom of page 12. Over to page 13, again, payment is collected from the grantee at the time of recording the deed. Bottom of page 13, it just clarifies what happens if the property is located in more than one county. Over to page 14, the bottom of that page, taxes are distributed based on population within the county. In subsection C, and this is what is new on page 15, Mr. Chairman, in this bill, per the request at the last meeting, is that if the local government receives any tax pursuant to this, their local government distribution would be reduced by 50% of the tax that they receive under this section. And you'll see there then on beginning on line 18, that's the intent of the legislature that a similar reduction be included in similar or subsequent bills providing for local government distributions. Mr. Chairman, over to page 16, the duties of the county clerk just directs the clerk to not record a document until there's documentation that this tax has been paid. Over on to page 17, again, that requires the Department of Revenue to adopt rules to implement this by July 1 of 2022. And that's pretty much the bill, Mr. Chairman.
Thank you very much, Mr. Anderson. Questions for Mr. Anderson? Any questions from the committee? Representative Sweeney.
Thank you, Mr. Chairman. Thank you, Josh. On this, does this sort out commercial and industrial properties, if there were any? I believe it does, but I just.
Mr. Chairman.
Mr. Anderson.
Representative Sweeney. It specifically excludes industrial property. I don't know that it excludes all commercial properties, but it does exclude specifically as currently drafted industrial property.
So
go ahead.
A follow-up to that. So on commercial properties, how would it work if you sell a property commercial and which could apply to an apartment complex? And you do a 1031 exchange or tax deferral method utilizing 1031 IRS codes. How do you see this interplaying with that is I guess my question.
So Representative Sweeney, would you mind giving us the background on that 1031 transfer?
So
It's a section of IRS code, right?
Yes. So, Mr. Chairman, basically on a sale, I don't know if it's done very much residentially, but I on commercial and industrial properties, but let's talk about commercial. Let's say I own an apartment complex, have a buyer, and what I can do is through a qualified intermediary, I can take with a 1031, I can defer my taxes, and then I have to, under a whole lot of guidelines, I have to buy like kind property and roll all of those taxes, whether it's from 1245 or different portions of the tax code, also capital gain, then that's all deferred, those taxes, and then you don't have to pay those taxes, and it goes into your next property that you're buying. And that's kind of a simplified manner, but there's lots of things you have to qualify in order to do this. But I'm curious how the 1031 on a commercial property would affect this particular tax.
Mr. Anderson, if you can.
Mr. Chairman, I'm not super familiar with that. From your explanation, it does sound like that was something that was applied to the seller. As drafted, this tax would be collected from the purchaser of the property. It briefly talks about, exchanges of property. I don't think that's quite what a 1031 exchange is, but anyway, I'm happy to look into that, Mr. Chairman. I don't think it's directly contemplated in the current draft of the bill.
So just jumping in here slightly, if it is some kind of an exchange, right, Representative Sweeney, you presumably you're selling something, and in order to minimize your taxes, you're taking the proceeds and you're buying something else. So it could potentially apply on the buying something else side, depending on whether that buying something else was covered by this bill or not. Would you go with that, Mr. Anderson?
I believe so, Mr. Chairman.
Thank you.
I think that would be correct too.
Okay. Thank you, Representative Sweeney. Representative Jennings, it's good to see you down there.
Thank you, Mr.
A
Chairman.
great compromiser.
Good to be seen, not viewed. Mr. Chairman, Mr. Anderson, my question is on page 15, and it has to do with the language and constitutionality. Just some clarification for me. It is the intent of the legislature that a similar reduction be included in any similar or subsequent bill. I thought constitutionally we were kind of kept from projecting onto future legislations. Could you talk a little bit, actually all the way through, because then on 23 it says it shall revert. And so if you could just kind of clarify that against the constitutional.
Correct.
Thank you, Mr. Anderson.
Mr. Chairman, Representative Jennings, yeah. And that is exactly why it's written that way, that it's just an expression of the intent of this legislature that it be included in that future bill. Certainly no requirement that the future legislature would follow that intent described by this legislature. So that was again, I think the purpose of drafting it that way is that it expresses the intent that is how this would be treated, but it certainly doesn't limit the future legislature in any way from drafting that bill however they see fit.
Anybody else? Kind of get that? It has to do with the direct distribution, and the suggestion is, it's not much more than a suggestion. If this tax is implemented locally by the vote required, that you reduce the direct distribution by half of the amount of tax in the future. So I'm sure that municipalities and folks will have something to say about this, but I think that's the intent. Anything else from Mr. Anderson? How about up there? Somebody on screen? Somebody? Senator James? Okay. Okay. Thank you, Mr. Anderson. Who else would like to testify about this bill? Ms. Henson, welcome. This is your first time out of the gate today.
Good morning, Mr.
Pull it
Chairman.
close, pull it close.
Good morning, Mr. Chairman, members of the committee. My comments will be brief related to the optional real estate transfer tax.
You still got to introduce yourself.
Brenda Henson, Director of the Department of Revenue. Good morning.
Good morning.
Just a couple of items that I felt needed clarified in that obviously the bill requires the Department of Revenue to promulgate rules and also prescribe the form that shall be used by the counties that have elected to implement this. But there's a lot of language within the bill that has been taken from the language in Title 34 that speaks to the statement of consideration that is filed. And that statement of consideration upon transfer of property, those rules and the form itself are promulgated by the State Board of Equalization. So what you'll see within the bill is some language that talks about that the county assessor shall hold it confidential, the County Board of Equalization, the State Board of Equalization. My hope is that I would be able to work with LSO because it's from reading this, it appears that the intent is that the Department of Revenue promulgates the form and the rules, and that this is very specific to only this real estate transfer tax. And so hopefully we could clarify some of that information. I have 2 pages that I'd like to turn to, one being page 6, and it's the basis of the tax in that small b.
Okay.
At the bottom of that paragraph, it talks about the tax shall be collected based on the most recent assessed value of the real property or interest that is transferred. My only question would be, as Wyoming is a fractional assessment state, meaning that the assessed value under our statutes is that 9.5% of either that fair market value or actual value. So just to ensure that the legislative body is accomplishing what they intend, should that be assessed value or should that be perhaps actual or fair market value? The other item I'd like to address is on page 13. Excuse me, 12, page 12. And on line 12, it does require that the document that will be prescribed, the form, must be notarized, which, if that's the intent, the statement of consideration that is used for State Board of Equalization purposes, those are not notarized, just as point of information.
Could you say that line number again?
On 11, excuse me, it starts on 11 and is noted on 12. The
I got it.
grantor and grantee shall
Got it.
sign before a notarial officer.
Mhm. So that's not required now.
It's not required on the statement of consideration. It may be that you may wish to have it for this particular document.
Thank you, Ms. Henson. Keep going.
On line 14, it does, again, it points to that the statement is not a public record and shall be held confidential by the county clerk, county assessor, county treasurer, county board of equalization, and so on. It's my understanding from the rest of the bill that the document that would be completed would be provided to the county treasurer as a basis for the real estate transfer tax, the treasurer would then collect that tax. And what would actually go to the county clerk would be a statement saying that that requirement has been met. So in my reading of the bill, perhaps this document only is seen by the county treasurer at the time that this tax is collected. With that, I'd stand for any questions.
Questions for Director Henson? Any questions? Anybody online? Anybody in the room? Director Henson, can I ask a question? If you know the tax rate, so is the taxpayer, when they pay their taxes, that's confidential, right? Wouldn't that be so? If the treasurer collects the taxes on a real estate transfer and say it's $10,000, just to make up a number, but no one can find out that that was $10,000, right?
Mr. Chairman, I believe you would have to stipulate that within the legislation.
Okay. Because that would undo the confidentiality of the sales and all that if it's just the application of a particular rate. So we might want to think about that connection. Anything else? Those were good. Why don't you stay with us for a second? Anything? Josh, did you get those proposals? Okay. Thank you, Ms. Henson.
Thank you.
Anybody else who'd like to address us? And you are the boringest crowd. Oh, here he comes, Mr. McLaren. Okay. I was expecting the back row to erupt. Mr. McLaren, welcome.
Thank you, Mr. Chairman. My name is Bob McLaurin. I'm with the Wyoming Association of Municipalities. Here to testify in support of the bill. Just a couple of quick comments. Basically, this is a bill, I think, when we talk about this local option real estate transfer tax, I think most folks think about this as a Teton County bill. As you're probably aware, the state tax structure incents high-end second home development, and it's occurring pretty rapidly in Jackson Hole. This has resulted in escalation of values and forcing locals out down valley and over the pass. So we believe this is an opportunity for the state to broaden the tax base and to, further diversify your revenue streams. With respect to the direct distribution, I haven't spoken to the town of Jackson about this, but given the latest revisions to the Madden formula, direct distribution doesn't really impact the town of Jackson or Teton County that much, but I would reserve the right to talk to them further about that. But just by way of reference, in calendar year 2020, there were $2.4 billion in real estate sales in Teton County, Wyoming. That was about 900 transactions. That was up 34% over the year before. And the forecast for real estate sales for 2021 is to exceed $3 billion. By comparison, taxable retail sales in Teton County was $1.5 billion. So it is a real estate economy up there. So I would ask your favorable consideration of this bill and would leave you just with this thought that real estate is to Teton County what coal is to Campbell County, except we get to sell it again and again, and generally at a higher price each time. But would appreciate your favorable consideration and would stand for any questions.
Thank you very much. Questions? Representative Sweeney.
Thank you, Mr. Chairman. Thanks for your testimony. And do you think with those numbers you just quoted, is $1 million threshold adequate, or should we move that, say, to 1.5 million to help the locals somewhat?
Mr. Chairman, Representative Sweeney, you probably should move that number up. I'm not sure what the number should be, but as of yesterday, there were 4 residential units that were on the market for under $1 million. And those were 1-bedroom condominiums. And they were priced between $675,000 and $950,000. So that $1 million exemption should probably go up. I'm not sure what the number should be, but yes, sir.
Okay. Representative Baker.
Thank you, Mr. Chairman. Are you comfortable with the language the way it is that includes the commercial properties?
Mr. McClure.
Mr. Chairman, Representative Baker, we would be open to however the legislature would draft the bill. I think, at least my personal opinion, was the intent is to try to deal with this on a residential basis. But if you look at other comparable resort communities in Colorado, where we're most similar, they capture pretty much everything. But I think from my own perspective, if you wanted to narrow it to just residential, we would be open to talking about that.
Follow up.
Thank you, Mr. Chairman. My question kind of builds on Representative Sweeney's question, which is the 1031. And it seems like a lot of these residential properties that I guess we're trying to capture with this tax, those aren't oftentimes primary residence. Those are investments. So we're going to create a loophole that exists, and without addressing the 1031 issue, I think that we're going to not really capture as near as much as we, I guess, would hope. So what is your feeling about the 1031 exchange?
Mr. McLean.
Mr. Chairman, I'm not sure I have a good answer for you right now, Representative. I think it's a complicated issue, something we have to talk through, but there are a fair number of 1031s that occur, is my understanding up there. But I'm not sure how you would capture that.
So I'm just want to jump in. I'm not sure that I understand why it's a problem, because it's a federal tax shelter, prevents you from having to pay a capital gain or reduces your capital gain, is what I understand. So I do understand that that's an issue when you buy and sell property, you want to keep those capital gains down, but this would come off the top essentially of the purchase, the exchange part, the purchase part. I'm not sure how the connection is. Maybe somebody could correct me. Would the federal government reduce the basis? You might by that amount? I don't think so. But you're out of my league here, but I'm not sure that I understand how the 1031 is important. So anyway, Representative Baker or anybody can help me with this.
Thank you, Mr. Chairman. So I wish Representative Obermuller was still here.
He's doing the happy dance out now.
Yeah. So so you don't get out of paying your taxes. It's deferred. But the advantage right now with the current administration, we're looking at a possibility of 31% capital gain. And today we're anywhere from 15 to 20%. But so I think that with the buyer paying the tax, that's the complication in my mind is, so I sell an apartment complex utilizing the 1031. Somehow I'd have to figure out when I buy the next like property, which is in pretty short order. I've got to have a number of things kind of lined up, but to make the stars align. But I think I am responsible on the buying end of that next property And I don't know if I can utilize any of the benefits of a 1031. I don't think I'd be able to. I'd have to come out of pocket for that exchange amount or for on the buying side.
Mr. McLaren, if you can help.
Well, I think, Mr. Chairman, it may be helpful to talk to some of our neighbors to the south where this has been implemented for probably 25, 30 years to see how they address that 1031 issue, because I'm sure it occurs in those communities as well.
It also strikes me that the buyer and the seller can discuss the tax implications for both parties as they go forward, and they'll be able to figure it out, and they can work out a deal with that in the mind.
My experience in the past was it was negotiated between the buyer and the seller. It was just on the closing statement. And it just varied from transaction to transaction, depending on the individual situations.
Right. Representative Baker, thank you.
Thank you, Mr. Chairman. I just have one more follow-up having to do with the discussion we had on page 6. It talks about the tax shall be collected based on the most recent assessed value. Do you guys take a position? Should it be on the assessed value, the market value, the purchase price? What's your feeling?
Mr. Chairman, Representative Baker, we haven't taken a
ahead.
position on that.
So I think Ms. Henson pointed out that technically your assessed value is the 9.5% times the market value, the fair market value. So when you get your tax notice, it'll have a box, it'll say fair market value. And then it says assessed value. So we'll decide which way we want to go with that. But I think the thinking was that this would be the market value, the fair market value, which is determined by the county assessor. So probably should say that. But we've got assessors in the audience and they'll help us with that too. And I didn't mean to jump in, but is that kind of your thinking?
Yes, sir.
Okay. Anybody else? I've heard that we have people online, so if there's no more questions for Mr. McLaren. Oh, Representative Roscoe.
Thank you, Mr. Chairman. Mr. McLaren, with these high prices that you described, astronomical, really. Can you describe any of the problems that these high prices in real estate have created for the community up there? Thank you, Mr. Chairman.
Well, there are a lot of softballs flying around here. Go ahead. Are there any problems in there?
There's no problems, just opportunities. Obviously, it's, it places a great burden on working class families. And if you were fortunate enough to buy a home, many, many years ago, as the values go up, property taxes go up, and, for some of those on fixed incomes. But what we're seeing in our community is, more and more people getting either pushed out down to Star Valley or over to Idaho, or those that are just cashing out that have been in the community a long time, just sell out and go somewhere else. And it's creating, obviously, like everywhere else in Wyoming, we have a shortage of workers. Restaurants can't stay open, can't staff the bus service, or it's hard. So.
Okay. Anybody else for Mr. McLaren? All right.
Thank you, sir.
You're off the hook for a while. Are there some folks online?
Yes, Mr. Chairman, there's 4 people with their hands raised online right now.
Let's get them let in. Maybe we'll take somebody else here first while we're getting them let in. Mr. Riemann, welcome.
Good morning, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. Earlier this year, my members did not take a position on this bill, and given that my membership has not changed, I'm not going to take one today.
Thank you for your testimony. Go ahead.
That said, Mr. Chairman, I do want to just talk to one provision of the draft bill. It's on page 15. It's provision C. It deals with the direct distribution. And I appreciate that this concept came from a presentation that I gave at your last committee meeting. My issue with this particular provision is that it suggests that just by simply passing the optional real estate tax, your direct distribution is cut in half. I think the intent was that for every dollar that you raised with the optional tax, that your direct distribution would be reduced 50 cents up to a maximum of 50% of your direct distribution. Hope that makes sense, but it wasn't.
It
just-
does, and I think your point's well taken.
Yeah, so if that could be changed, that would be certainly appreciative on our part. But Mr. Chairman, other than that, I have no other comments.
Okay, just on that point, he's absolutely right. If you go to page 15 and you look starting on line 13, any fiscal year distribution of the local government shall be reduced by 50% of the tax distributed to that local government under this section. That seems to tell me that that's the tax that they actually receive as I read that. What do you think?
Mr. Chairman, as I read it, because the 50% is tied to the direct distribution language, but perhaps LSO's intent, it matches what mine, but
So I think there's just kind of a maybe we could add a few more words to be clear. It's clear to me, but Josh, what do you think?
So, Mr. Chairman, yeah, I think the intent as drafted is that it would be reduced by 50% of the tax that's actually distributed. What it wouldn't have is what Mr. Ryman said about a maximum of 50% of that. So that would be something that would need to be added, Mr. Chairman.
Would that be, maybe you could work on some language?
Mr. Chairman, if this moves, I will certainly do that.
Okay. We'd like to amend it today if we could. So, all right. Any other questions for Mr. Riemann? Thank you very much. Ms. Huxtable, are you okay waiting for a minute? I said we'd take some people online and we'd let them in. And so let's start with Mr. Moline. I think he was there. I'm not sure what he will say, but I can venture a guess. Mr. Moline.
Mr. Chairman, Brett Moline, Wyoming Farm Bureau Federation, sitting in opposition to this concept. So one of my concerns with it in a general form is, are you going to have some unintended negative consequences of reducing property values, perhaps not in some areas, but in other areas, so that you would gain the money on the transfer tax, but knowing that a property buyer has to pay this additional tax, would that in turn push down the purchase price, which would then affect fair market value and the assessed rate? So you would gain on the transfer tax, but you would lose on property taxes. That seems to be a concern that it is a concern that I would raise. And then on page 4, lines 12 and 13, right now, the wording is at least 50% of the municipalities would have to sign on to get it in front of the voters. I would suggest changing that to over 50%. I realize that the county would also be another entity that would have to sign off on it. But it seems like to me, and most times 50% vote, the issue dies. I believe that's the way it is in your committees and on the floor, in the houses on each side, that 50% vote, the issue dies. It has to be over 50% voting in favor of it. So I would suggest changing that to over 50% rather than at least 50%. And should this bill go forward, which we don't want it to, but I would, if it does go forward, on page 9, line 18, it says, that it exempts agricultural land. I would suggest changing that to agricultural property. That would kind of coincide with the exemption of the industrial, that all industrial property would be exempt from this tax. And my point on that is a lot of times a lot of the farms and ranches have quite a bit of money into barns, machine sheds, et cetera, buildings associated with agricultural use. But I realize that the housing unit would still be subject to this, if it was over $1 million, but I would suggest changing that from land to property to be more in line with what's going on with the industrial. But again, we don't like the concept, but if the bill does go forward, I would appreciate those changes. With that, Mr. Chairman, committee, I'd sit for any questions.
Thank you, Mr. Moline. Questions for Mr. Moline? We've got Representative Yin online.
Mr. Moline, Mr. Chairman, thank you. Mr. Moline, so if there was a side effect of reducing the property tax that every person in that county that accepted the real estate transfer tax had to pay, are you telling me your members would not support a reduction in their property tax as a side effect of this?
We would really appreciate the
Mr. Moline.
reduction. I'm sorry,
Mr.
Mr.
Moline.
Chairman, I violated protocol. Accept my apologies.
You got excited. It's okay. Go ahead. Mr.
I tend to do that, Mr. Chairman. Oh, no, we'd always appreciate lower property taxes, but we also have to realize the impact on the counties and other entities that rely on property taxes, conservation districts, water districts, if it's based on assessed valuation, cities, right now they're screaming for money. And if you have a negative impact on the property values, it'd be good for it'd be good for my members if their housing unit was over $1 million. But we also have to consider the entire economy, and we don't want to be hurting the counties and cities, I would assume. I hope I answered your question, sir.
Thank you, Mr. Moline. Any other questions for Mr. Moline? Any other questions? Risk of venturing in, I don't know. Okay. Who else? Thank you, Mr. Moline. Who else would like? We have somebody else online?
Yes, we have Anna Olson from the Jackson Hole Chamber of Commerce.
Ms. Olson, welcome.
Good morning, Mr. Chairman and members of the committee, and thanks for hearing my comment. Spoke at your last Revenue Committee in favor of this bill and remain in favor and ask for your favorable consideration on behalf of the Chamber of Commerce here. Have spent the last few weeks talking to friends and colleagues around the state in Rock Springs, in Cheyenne, in Casper. This is a local option bill, and I just want to reiterate that it's because it might not work for everybody, but giving the choice to the town and county to look for solutions that work for their environment is something that we really support. And I found general support for that concept. And I would say to the other public comment that in resort areas, there is absolutely no evidence that this type of tax reduces price. That is obviously specific, as Mr. McLaurin was saying, to this area. But I just like to, point that out, that is this a local option for local solution? And we need those options here. We are losing our employees. My number one issue for employers is the lack of employee housing here, and it's getting worse by the day. I sent public comment. We are now on record that there is no solution for 120% MFI and below outside of public funding and building it that way. That is the majority of the working class in our area, and that number is going up. So I would ask you to consider moving this forward. You have heard from realtors in our community, working integrated with national and international brokerages. They don't see this individually as something that, they see this as a working solution, and you have heard written comment from those individuals. And I look forward to getting more of that and working. It's not going to be perfect for everybody, but I ask you to move this forward today so that we can have further debate and potentially provide solutions, in our case, probably for housing, that we absolutely need. Thank you for hearing my comment today, and I'll stand for any questions.
Thank you, Ms. Olson. We've got some questions from Representative Baker. Go ahead, Representative.
Thank you, Mr. Chairman. Just want to make a comment first up. I I am a Realtor, and we did receive a poll from the Realtors after the last meeting, and I don't see the lobbyist here, but we did receive a poll, so we had an opportunity to vote as an organization and as Realtors as to whether we felt that sale prices should be made public. So that was interesting. I'd love to see the results of that. I think that Realtors in general oppose the idea, and so I as a Realtor, you know, it's difficult to speak for every one of us as an organization, but the lobbyists haven't taken a position on this. So I just want to caution, you know, the public for the assumption that Realtors are on board with this idea, because I don't think that's accurate. But if you could, what portion of your residences up there do you believe are primary first residences, only residences of those individuals?
Ms. Olson, and if you can answer this question, I might add, I thought Ms. Olson's testimony was that the local Realtors in Jackson she felt were supportive, but let's let her address that. So go ahead, Ms. Olson.
Mr. Chairman, may I respond? I absolutely do want to clarify. There is not a group position on, I am not speaking on behalf of any Realtors or group of Realtors. Okay. I am just saying there were some individual Realtors who I spoke to who confirmed they would be making written comment in support of this. So that, just to clarify that, I am not speaking on behalf of any Realtors, local or statewide, and I am not speaking on any groups. I'm just saying that there would be some individuals who are going to make comment on this. The second question with regard to how many primary houses, I do not have that information, but would happily send that off to the committee once I've spoken to the Housing Authority and some other sources here.
Wouldn't we expect with global warming that more and more people would have their primary house in Teton County? That's kind of a joke. It was sort of meant to be a joke if the snow keeps you from having it be seasonal, but back to you, Representative Baker. I know you had more. Thank you. Sorry about that. That was terrible. Who else? We have one more. Oh, Representative Roscoe.
Thank you, Mr. Chairman. I don't know if it's appropriate that I respond to Representative Baker's.
Wouldn't you agree? That always helps.
Okay, I'll try that.
So for Ms. Olson.
I just think that if we portray this as a statewide issue, it's really not. It's not really even the tax that we're voting on. We're voting on the option, and it's really is specific to that county up there in the Northwest, and it just has to. It wouldn't work in many of these other counties, but it is a problem that we have, and I think it has to be looked at as a local option. That's what. Kind of,
wouldn't you agree, Ms. Olson?
Wouldn't you agree, Ms. Olson? Thank you.
Mr. Chairman, yes, I would agree.
Thank you very much. Any further discussion, questions for Ms. Olson? Thanks, Ms. Olson. Is there anybody else online?
Yes, we have two more online. The next on our list is Lori Urbicite from the Wyoming Realtors.
The Realtors have shown. Ms. Urbicite. Can you get on?
I'm trying. Hold on.
We hear you.
There we go. Nope, my video is not starting. There I am. Okay. Thank you, Mr. Chairman. Lori Urbicite with the Wyoming Realtors. And obviously, we are opposed to this bill. We always have been and probably always will be. We do appreciate that the sponsors or the people that bring it forward are creative and have worked to try and change it up a little bit so we have other things to discuss. Before I forget, I did want to address the 1031 exchange issue. And I don't see, I think, Mr. Chairman, you are absolutely right. I do not believe that this bill has anything to do with that whatsoever. In a 1031 exchange, you're selling a like property and then you're promising to buy other like property with those funds. So the seller would be selling it. Now, whether the buyer of that property is involved in a 1031 exchange or not has nothing to do with this bill. The buyer is going to have to pay that tax on whatever the purchase price of that property is. Then the seller, and the seller's the one that gets the tax benefit, they don't have to pay the federal taxes on that property on the capital gains if they then use that money to purchase other like property. They don't have to identify that like property immediately. So again, I don't see that this bill would have any effect on 1030. Seller going to have to pay on whatever the purchase price of that property is. I just wanted to clarify that. But our reasons for opposing the bill. First, we do not
Hold
believe it's
on.
constitutional.
Ms. Erbicott, can you hear me? You're cutting out a little bit. And so let's try to get your internet caught up. And Representative Baker, one of your members, I think, has a question.
Well, I had a question regarding the 1031 exchanges. And I think that what you're saying might be accurate based on the county classification, land classification, if that's correct. Because right now we're dealing with not only personal property, but commercial property as well. So it would depend upon the land classification based upon the county, because if someone wants to do a 1031 exchange on a commercial property, it may be impacted, if I'm right still. Is that correct? It would be based upon the classification of the county, the land, how it's classified.
So, well, let's set this one aside. I'm not sure that I understand how the federal classification and whether you qualify or not depends on what the county calls the property. But can we get more research on that in the background? Ms. Erbicott, you're not prepared to clear that up, are you?
Mr. Chairman, I've turned off my video to see if that'll help my internet speed any.
That probably will. Thank you.
Thank you. So when I talk about like-kind exchanges, the issue is it an income producing property? And so if I have, as Representative Sweeney had mentioned, if I have an apartment building, that's an income producing property, I have to, in order to get that 1031 exchange benefit from the IRS, I have to invest those funds in a like property. So it has to be an income producing property. Those are kind of the qualifications. Whether it's a commercial or not does not matter. It's whether or not it's an income producing property. That's my understanding. I used to do 1031 exchanges as a real estate broker years ago. I have not participated in any for many years. So that's my understanding. And with that, Mr. Chairman, I'll go back to my testimony. As I was saying, we do not believe it's constitutional. Article 15, Section 11, Paragraph D of our Constitution says all taxation shall be equal and uniform within each class of property. When you have now exempted industrial property, this is no longer equal within each class of property. We also do not believe this reliable source of any municipality or county to rely on. Certainly the real estate prices in Teton County make it very attractive, but the reality is that property values do go up and down. Now, do they go down in Teton County? Probably not as much as some other counties may see, but the market does slow. And certainly in Teton County, I would think that the global economy has a lot to do with whether or not it's a robust market or not. And then we look at the equity of it. In many cases, and certainly in the resort areas of our state, a lot of the real estate property that's purchased is purchased as an investment, truly. And so putting a sales tax on those investments is not equitable when we do not put a sales tax on stocks or bonds or those kinds of investments when people sell those. Real estate property is already taxed. And certainly with the rise in the values in Teton County, they're certainly seeing a rise in the property taxes. I found that the reduction of the direct distributions on page 15 was very interesting. I don't really have a comment on that. I just thought that was an interesting new twist to this. And then finally, when we talk about the issues that some of our counties have, and quite frankly, I'll be honest, I think we have an issue for workforce housing across the entire state. It is not just a Teton County problem. It is a problem across the state. And other counties are working with the private sector to try and come up with solutions. We offered to put on a town hall in Jackson in October to work with them to see if there are solutions, I'm certainly not going to say I have all the solutions, but I thought that, starting a dialogue with private enterprise, with the private businesses, and with the municipality and the county, that maybe we could come up with other solutions. We firmly believe that there are ways that the private sector working with the public can solve these solutions. And I don't believe that just giving them a whole bunch more money through a new tax on real estate is going to solve all their problems. And with that, Mr. Chairman, I'd be glad to try and answer any questions.
Sorry, my mic was off. Thank you, Ms. Erbekite. Representative Baker has some more questions. Representative Baker.
Thank you, Mr. Chairman. I just have a couple quick questions. One, do you have the results of the poll for the realtors and how they feel about disclosing sale price? And then two, in this bill, it's contemplated that it would be based upon the assessed value. What's your feelings about what the tax, if it were to move forward, regardless of position, should it be based on the purchase price, the assessed value, the market value? What do you feel?
Ms. Erbekite.
Thank you, Mr. Chairman. Representative Baker, the poll that was done by me, and I am not a pollster, and I did not ask the question probably appropriately, but indeed you were correct. The people that responded to that poll it was an overwhelming majority were opposed to releasing the purchase price or the sale price on real property. We are in the process of working with the National Association of Realtors and having a national pollster do an in-depth poll, both of the public and of our members. And so as soon as I get results from that, I will make certain that that is provided to the entire committee. As far as the price, we hate a real estate transfer tax. I don't care if you tax it on assessed value or market value or purchase price. We're opposed to the tax. We just simply are. Obviously, if I have to pick one, I'll go with the assessed value. But I would add, and I failed to mention this in my original testimony, that you're also going to run into a situation where some of these, especially real expensive properties, are sold via corporations, via stock sales, and how you're going to assess that, how you're going to know if an LLC has sold portions of its holdings. I think you've got a real question there. And certainly with corporate properties and how maybe stock exchanges are facilitating the change of ownership that the county assessor may never know about. So I hope that answers some more questions. Thank you.
Thank you very much. He's got a follow-up. Go ahead, Representative Baker.
Thank you. I don't want to draw this out too much. I just want to follow the logic behind it, because when we charge tax on a vehicle, we don't charge it on the manufactured suggested retail price or the Blue Book value. We charge it on the actual agreed to amount. So what's the reasoning? Is it just because the assessed value is the lowest and that would create, or could potentially be the lowest? But what would be the reasoning behind taxing the assessed value that the person has no control over, really?
So now let's go. I want to look at that real quick. Doesn't that only apply, Josh, in the sense that if it's some kind of a grant or a gift, you go to the assessed value, which is probably the wrong word, to get a pseudo value to fill in as a proxy for the actual exchange price. Is that correct, Josh?
Correct, Mr. Chairman. Yeah. So the tax applies to the actual consideration paid, but if it's something without stated consideration or nominal consideration, then that's when the bill currently would use the assessed value that's included in the bill. It probably was the intent to actually have that be the market value rather than the assessed value.
Yeah, and if you really thought of it, the market value is determined by the assessor, is what we'd really probably want. Does that help? So it's the basis of the tax is the exchange price, I think, is what the bill proposes. Ms. Erbekite, did you have anything else?
No, Mr. Chairman, I think that covers it.
You did great, even without video.
Thank you, Mr. Chairman. Thank you, committee.
Who else is online?
We have one more on our list, Mr. Chairman. We have Vice Mayor Jorgensen from Jackson.
Representative Yen, I saw you had your hand up. Was that a question for Ms. Zerbekeit before she? left?
Yes.
I
Mr.
apologize. Ms. Zerbekeit, are you still available?
I'm here.
Okay, Representative, and I didn't see him and it's my fault.
I'll speak up next time. Mr. Chairman, thank you. Ms. Urbikite, I was wondering if you know how many states currently have a tax such as this?
Mr. Chairman, Representative Yen, I do not. I used to know that number. I will tell you that in the past 10 years, several states have passed constitutional amendments permanently banning a real estate transfer tax. We've contemplated that and contemplated a bill regarding that in Wyoming, but at this juncture, we did not see a path forward. So we have not pushed that full force, but I do know there are many states. I think there's 14 or more states that have already passed a constitutional amendment permanently banning it, but I will look up the rest of them and get back to you.
Okay, is that acceptable, Representative Yen?
Sure, Mr. Chairman.
Okay. Okay, now you're off the hook, Ms. Urbikite, and it's Assistant Mayor. Welcome.
Thank you. Thank you very much. Trying to get my video. There it is. Thank you.
Great.
Thank you. Thank you, Chair. Chairman, I appreciate the opportunity here to speak and in speaking for and in support of this proposed bill. And I want to thank everybody for the work done on this.
And you might introduce yourself.
I'm sorry. Thank you. I'm so frequently say that. Arn Jorgensen, Vice Mayor of the town of Jackson.
There you go.
Thank you for the reminder. And as has been alluded to several times in this morning's discussions, we are facing many, many challenges around housing in our community due to costs of that real estate and the pressure that we see from this very intensive market that we have locally. And there are, in the last 6 months, we've listened to many, many dismaying accounts from constituents and fellow community members who have moved upwards of 10 times within a matter of years, from people who work high-paying jobs and barely make ends meet in our community, and from business owners who cannot keep their stores and restaurants open because of their staff not being able to find a place to live. I'm immensely proud in our community and that we're banding together. I appreciate Ms. Olson's comments in particular about thinking creatively about gathering more resources so that we can address these issues for this community. One of these great ideas, and we've had many discussions over the years, is a tax on real estate. This is a tool that is used in other states, particularly neighbors to the south. And it's something that would provide us tools that would allow us to address our issues here locally, reducing the request that we may have to the state and increasing benefit to our town and county, as well as the entire state, and kind of reinforcing our recapture status that we are proud to be able to do in support of the state of Wyoming at this point. I realize that not every part of Wyoming would be interested in utilizing this tool. It's very much of a local option. One of the suggestions that I'd like to make, I think it was Representative Sweeney that was asking about the $1 million. Maybe perhaps that could be part of the local option, because clearly that number would be very different in a county like ours, in Teton County, than it may be in other counties around the state. So that may be a way to reinforce the local way that this tax may come to bear and make it more palatable to other communities if they choose to use it. And I just want to really reinforce that local entity. I think Representative Roscoe was also doing so. One of the a couple of things I want to go into. Real estate sales, as Mr. McLaurin acknowledged, have been in the billions, over billions of dollars this year. Real estate sales tax would benefit our town and county, but also the entire state. And I think that's an important element. In a recent public comment that we received, we had a constituent who was quoted to say that we need to address these challenges. We need to find additional resources just to keep the wheels on this point, keep the wheels on the bus, for businesses to stay open, for teachers, first responders, and other integral members of our community to remain as our community. And I want to reinforce the business element to that. The pressures we're seeing on our real estate in our community, we are simply, if you're earning your money locally, whether as a business owner, as an employee, you cannot compete with the amount of wealth and interest in our community's real estate. That doesn't matter whether you're an employee or whether you're a business owner. Small business owner that wants to help provide housing for his employees cannot compete in our current market. And this allows us to take steps to help address some of those needs. And there were a couple of comments. I mentioned the $1 million one. I do want to acknowledge the direct distribution discussion. Certainly as the town of Jackson, we recognize that that's a completely reasonable discussion to have. It's not something that our council has taken under consideration, but speaking for myself, I think that's a worthwhile exchange. We would gladly take care of that. I also would like to address some of the realtor comments as Ms. Olson was talking about. I have also talked to many local realtors, not taken any official poll. And I have talked to many of them that are in support of this tool and recognize that, as was commented earlier by Mr. McLaurin, that the real estate is our asset. Real estate is our coal. And this is a way for us to be part of the state in terms of revenue and to reduce the time that we're coming to the state and asking for assistance. I could go on, but I will just stand for questions at this point. I see a couple of hands up. Thank you so much, Mr. Chairman.
Thank you, Vice Mayor Jorgensen. It's a pleasure. Who would like to go first? I see Representative Gray. I see your hand is up, and then let's go to Dr. Hallinan. Go ahead, Representative Gray.
Thank you, Mr. Chairman. I'd like to ask, I just want to get the figure on how much this would have raised in Teton County last year. So do you have that, or do you have the aggregate? I know we got that earlier, that aggregate real estate amount in 2020 or 2021 through November.
Mr. Vice Mayor. Mr. Chair, Representative Gray, I do not have that number off the top of my head here. We can certainly get that to you. My recollection was total sales over 2 billion, but again, I don't have that written down right here in front of me.
Okay. Back to you, Representative Gray. We're good. Thank you.
Thank you, Mr. Chairman. I'm not understanding this concept of, well, this is going to fund, quote unquote, as some label it, quote unquote, affordable housing projects. I mean, that's just an assumption that these funds are going to be used for that. I mean, why doesn't the town of Jackson, Teton County do that with their, if they want to, with their current funding situation, which I think is quite ample. I'm not understanding why this is needed for that if the town of Jackson and Teton County have decided that that's a priority for them.
Mr. Vice Mayor, if you can.
Chairman and Representative Gray, thank you so much for that question. It's a great question. And you're right, we have other revenue sources. The challenge with some of those other revenue sources, they also impact, as some of the earlier public comment had been made, people on a fixed income, for example, if we're talking about property taxes, it impacts people that are trying to make ends meet. What we appreciate about this particular tool, it's directly focused on those that are outbidding the locals. They're outbidding whether it's a business owner, commercial property, or residential. And that amount of interest and that amount of activity in our real estate market, we just can't compete against. So the town of Jackson is going through a very intensive process right now, looking at all of our revenue sources. And so we are not, and I will add, and this is a discussion I've had with several of you over the years, the town of Jackson has put in place a property tax for the first time in 40 years. And I want to reinforce that. We recognize we need to do a better job of taking into account our current revenue sources, and we're willing to do that. The benefit of this tool is frankly the dollar numbers. And this allows us to do many, many things. You keep hearing us talk about housing as from most of our expectation is that would be part of the ballot question, but most of our expectations is housing would be a significant element of that. There were comments made about other opportunities in the private sector. All of our recent, I'm pausing here a little bit, all of our recent efforts for affordable or community housing projects have partnered with the private sector. And I want to really reinforce that. That being said, in order to make that public that private sector project pan out, we are investing in that either by providing land or providing other means of subsidy. So what these revenue sources allow us to do more of that. It allows us to partner with the private sector and the nonprofit sector. It gives us the resources to, again, buy down these developments and these purchase prices so they can be afforded by those that are earning their living within our local economy. We frequently hear, well, let's just do more supply. And we're also, the town of Jackson did a significant upzone in 2017, where that's one of the solutions. But we have learned for 30 or 40 years, the supply alone in a red hot market like we see in Teton County does not maintain affordability. We cannot build our way out of this. And there's for a number of reasons kind of embedded in that. But thank you, Mr. Chairman. Thank you, Representative Gray.
Okay. Thank you. Thank you both. How about Dr. Hallinan?
Thank you, Mr. Chairman. At 2.5 billion, 1% would equal $25 million annually. I see the problem that Teton County has is the lack of land. It's not the lack of buildings. So with 2.5 or with $25 million, aren't you just going to bid up the price of land? And how is that going to help people that can't find a place to live? I don't really see how this is really going to help anybody unless you take that 25 million and buy land in Lincoln County or in Fremont County for people to live in, because the price of land is so high in Teton County. I don't see how any amount of money can be used to provide housing for people there that work on a wage in a small business. I don't see how you can do that. So with that in mind, I'd like to hear what you have to say about that.
Vice Mayor Jorgensen.
Thank you, Mr. Chairman, Representative Hallinan. Great question. And I think it's something that's a really important kind of reality we face. The choice is we cannot afford it today. And the purchasers of the real estate market in Teton County are people moving into the community, bringing wealth from somewhere else. There's no way to compete against that unless we're finding ways to buy down those expenses. We've been doing community housing, affordable housing projects for 30 years. We have over 1,400 units that are in that pool within our community. And the way that that's taken place is, I mentioned the private-public partnerships. We have two projects that I'm thinking about off the top of my head right now, where the town, there's three, where the town or the county is providing the land to a private developer or a nonprofit. We're finishing up a fourth. I'm sorry, they keep coming into my mind. So we're taking the land out of that equation. And then that private developer or the nonprofit is then building the units and making them available at affordable rates for people working, as you alluded to, for wages within Teton County. And we're doing that, and we've been focused on this as a way to preserve our community, as a way to maintain a sense of community so that we're not seeing community members having to drive over to Idaho or down Valley. If they choose to do that, that's a fine solution for them. But we're trying to preserve a sense of community, take advantage of the fact that we are a resort, but also do so that people that are living and working within our community can afford to live here. Some of them can, not all of them. This will not be a tool available to everybody.
Thank you very much for that. Just want to kind of take a breath here for a second, just remind folks, we still got a long agenda today. And if we can get to the heart of things with our questions and our answers, that would be more acceptable. Dr. Hallinan, any follow up? We good? Okay, got loud and clear there, Doctor. Senator James.
Thank you, Mr. Chairman. So to me, it just sounds like this is just another way for government to compete with the private sector and dictate who gets what and affects the free market. That's from your testimony, that's what it sounds like. Would you not agree?
I think that's you, Vice Mayor.
I want to make sure you were acknowledging me. Thank you, Chair. Senator Gray. We would.
Senator James is asking.
Oh,
a
I'm
question.
sorry, Senator James,
Okay.
I missed that. Sorry about that. When this money, if it is used for housing, again, that's one example, we would be part of the real estate marketplace. That over $2 billion is the marketplace we're talking about. And so the amount of the government investment in this scenario impacting that marketplace, I do not feel would be significant. Thank you, Mr. Chairman. Thank you, Senator. I apologize for that.
It's okay. All right. Anybody else? Anybody else online?
Yes, Mr. Chairman, it looks like Anna Olson had just re-raised her hand.
Can we get back to Ms. Olson after we hear from the other witnesses here? So tell her to stand by.
Ms. Olson had to go to a meeting, Mr. Chairman. That's okay.
I'm sorry. I hope maybe she could relay that question through you, Representative Yen, if that's possible. Assessor Huxtable, welcome. Thanks for being so patient.
Mr. Chairman, members of the committee, I'm not going anywhere for a couple days. I'll be here. So I'm at your pleasure. Dixie Huxtable, Converse County Assessor, today talking on behalf of the Wyoming County Assessors Association. We did not take a position on this bill, but we did find a couple of comments that need to be clarified. And I think most of them have already been briefly talked about. The first one was that discussion about on page 6 about most recent assessed value. Just as a reminder, assessed value is taxable value. Typically what's reported on a statement of consideration is fair market value, or in our language, sometimes it's called actual value. It would not seem to be very fair and prudent to be using a fair market value in one scenario, and in somebody that didn't report or put a nominal fee gets the benefit of the taxable value, which is a fractional of that fair market value. So I would think that you would want to consider changing that assessed value to fair market value, actual value, something that really does represent the full value of that property, not a fractional.
And so that would be the value that the assessor's office puts on your notice, right?
Correct. The fair
So-
market value or actual value of your property.
Would it be helpful? I'm just asking if it said, say, fair market value as determined by the county assessor, just to
Yes.
be clear, because fair market value sounds generic. But in this instance, we're talking about a very specific type.
Mr. Chairman, yes, that would probably be appropriate with the exception of agricultural, which is being exempted.
Yeah.
Which is another topic that I'm coming to because that's at production value. So
Continue. You go ahead.
the other part of that sentence is recent. Just as a reminder, if property sold in January or February, the most recent value that the assessor would have would be the previous year's value. If property sold in July, the most recent assessed value would be the current year's. Not a problem. I mean, that's perfectly fine, but just make sure this distinction when you say the most recent is whatever is most recently public. Typically, when notices of value go out in late April, May, that is when the value becomes public.
Gotcha.
And so now you may have at different times of the year, different values that you're looking at for this scenario. So I just wanted to bring that to your attention. And then on page 9, when you're talking about the exemption for agricultural land, just a clarification, was it classified by the assessor at the time of the sale? Is that the intent? Or is it the buyer's intent to use it as agricultural that causes it to be exempt? We have a lot of property that was residential when it was sold by the seller, and then after the buyer buys it, they apply for agricultural status, and then in the next year it may become agricultural. So to make sure what the intent was it agricultural at the time of the sale, and was that determined by the buyer, the seller, or the assessor? Because that could be a different interpretation, and that could follow through with industrial as well. Sometimes property is commercial, and then after it sells, it becomes industrial for the use of it. So there are some nuances there to get cleaned up in rules if this was to go forward, and make sure everybody understands what we're talking about. And with that, I would stand for any questions.
Okay. I'm not seeing anybody that brave right now. So let's just talk about the agricultural value to begin with.
Certainly.
So just let's pick on Park County for a second, because we had this agricultural ranch in Park County that became like a national spot with all the celebrity watchers there as that property became was purchased and was someone very famous. And I'm sure they kept their ag exemption. But is that really what we want to do? Or if these trophy ranches transfer for huge amounts of money, and really, honestly, we all know that the agricultural piece of this is kind of de minimis. Isn't this tax? I'm trying to understand why there is an exception for agriculture properties, especially in like Teton County, for example, and what would be classified as ag in Teton County or other counties. Can you help me think the way through this? And I know that you guys aren't taking a position on this. Wouldn't it be fair to say that some people overpay for agricultural property, not because they want to use it to sell cows, it's because they want it for the lifestyle, the privacy, the status, the enjoyment that that property gives them, which is proportional more to the sales price than to the ag value. So maybe help me with this.
Mr. Chairman, I did not put that language in the bill. It came with it in the bill. And certainly we have agricultural property that sells in excess of millions of dollars and way more than its productive value that we are assessing it for. So the intent of it exempting them, I don't know the reason why. I can guess why the reason is. But there are a lot of agricultural land in this state that meets the minimum requirements of the ag status as it currently is written, but may not meet the intent when it sells. And so it goes back to that theory of the guy that owns it is using it to meet the criteria of an agricultural rate for a production value, lower taxes, but sells it more at a market value than a production value. And this bill would exclude the difference, certainly. If the property is being valued at a production value, but the market value is maybe 5-10 times that, or even more, that portion is going to get excluded from this bill.
And just if I could tag on for everybody to draw this out just a little bit. If indeed someone bought a property intending to use it for agriculture, it's in the, it's their business. They're driven to pay production value. I would think that would be, so that would mean that the price would be relatively reasonable unless their business is land speculation. But that's a different animal. That's not an ag thing. So I'm wondering if we all ought to think about this agricultural exemption in this process. Ms. Huxtable, I kind of appreciate your being willing to speculate on that a little bit. Yeah, it's just, to me, this is a big bugaboo that we have pieces of real estate that are sort of nominally ag, and they are paying annual property taxes based on ag production. But we all know that it's not ag when it's sold. You're buying a trophy piece of real estate. Maybe your intention is to subdivide it down the road. Maybe you're just going to keep it forever. Maybe you're going to find another wealthy person that might take it over when you get older. And chances are it has nothing to do with ag production values. I just throw that out. Any other questions for Ms. Huxtable? I'm sorry. Thank you. Thank you, Ms. Huxtable. Anybody else in the audience? Mr. Steenberg, welcome.
Thank you. I'm Dale Seamorgan. I'm President, CEO of the Greater Cheyenne Chamber of Commerce. We support this bill. I will tell you that as I was procrastinating going out and feeding my cows on this cold December morning, I was looking through my Facebook, and I can't tell you how many posts I saw from folks either directly in or related to state government in Wyoming griping about federal problems and saying, the best way to solve those is get them down to the people that actually live there. Right. And then we're sitting here talking and working over the vice mayor there about what he might do with this property when all he's saying is, let me make the decision in my community. Right. you will talk to your communities, they need tools. We've got problems. Housing in Laramie County, we're 4,500 units short. We're desperately in need of it. So we'd probably like to talk about that cutoff amount because if it was 1.5 million, it wouldn't allow us to use that. But basically all this bill says is that if you as a county government, you and your neighbors agree that you want to go to the polls and vote to impose a tax on yourself to correct a problem in your community, that it allows you to do that. Why in the world would we not want a local government to have a tool to send to their people for a vote of their people, and their people say, we want to raise our taxes so we can live in a better place? I'll keep it right there and answer any questions.
Thank you, Mr. Steenberg. Questions for Mr. Steenberg? Is that Roscoe? Representative Roscoe, then Sweeney.
Thank you, Mr. Chairman. Mr. Spielberg, so do you see that this bill could actually work the other way as far as if this community wanted to remove, once they put this tax on, they could remove it when they saw fit? Does that look like a
And
possibility?
I think in the language, it actually
Mr.
goes away,
Steenberg,
right?
just a sec here.
Oh, sorry.
Take a deep breath. Go ahead.
I think in the bill, it actually, they have to vote on it pretty regularly to keep it in place. So if the attitude of the voters change, they can take it away, right? But it's the voter, it's the person living there making the decision, not some government upstream, which seems to be a principle that we are very committed to in this state. And I think we ought to apply it all the way down to the local level.
Thank you, Mr. Steenberg. Josh, is that correct? Is there a mechanism in the bill for the pullback?
Mr. Chairman, there is a requirement that the proposition be voted on at the second general election following the initial proposition, and then every 4 years thereafter.
Got it. Thank you. Okay.
I
Representative
read the
Sweeney.
bill, see.
You did good. Representative Sweeney.
Thank you, Mr. Chairman. So do we put a number like $1 million, or is there a way to address that to give the county the option of a placeholder? I'm not sure we can do that, but I appreciate your comment on the movement of that, because as it applies to different counties, it might be different things. So,
Mr. Steenberg, thoughts on that?
I guess my opinion would be that each county is best suited to make the decision on that, right? So I mean, my folks in Laramie County, the folks that live here, they're going to know their county. We're going to know where that threshold is. Costs of living differ, costs of housing differ. Maybe there's another problem they need to solve, but it might look a little different everywhere. And so it would seem to me that these decisions, as we drive them down closer to the people, those decisions are made better and they're more effective.
Thank you. Anything else from Mr. Steenberg?
Thank you,
Mr. Steenberg. Thanks a lot. Anybody else in this room? Joe, welcome. Mr. Assessor is here. Treasurer now. I'm sorry. Yeah.
I'm Joel Shell, Treasurer in Commerce County, and Mr. Chairman.
Pull that close, Mr. Shell. I'm sorry.
Briefly, I wanted to address a couple of the confidentiality provisions.
Go ahead.
I think it's clear in the bill that the document that's used as the basis of the tax is confidential, but the payment would also generate a receipt that would be subject to the Public Records Act. So it should also be clear, if your intent is that receipt not be disclosed, that's explicit in the bill. So we're not caught between this misdemeanor provision and the Public Records Act. What's more concerning is our revenue streams. Right now, all of our revenue streams are public record and we track them separately. So we would track this as a separate revenue stream. It would be real estate transfer tax collections. Currently, any citizen or the newspaper or legislator can contact their county treasurer and ask how much we've collected in a specific revenue, whether it's taxes or fees or sex offender registration fees, whatever it is, in a certain period, whether how much did we collect this week or this month or today, yesterday. And we would disclose that. And so we, again, would not want to be caught with that subject, to that provision that said we disclosed something from that document that would tell somebody what that amount was. And if that was deemed to be confidential, we would need to know how far that went. For example, we disclose on our public or on our financial statements each month to the county commissioners what we get in each revenue stream. So if you were averaging maybe one of these sales a month, then, you know, basically anybody could take that amount that you had received in that month for the real estate transfer tax and extrapolate the amount of the sale that occurred in that time. So those are our concerns about the current problems with confidentiality and how difficult it would be to keep it under wraps, Mr. Chairman.
So conceivably, Treasurer Shell, could we exclude the receipt that matches the confidential sale, but be silent on the request for issues in a period? Or maybe go a little farther and say, unless it resulted in the disclosure of an individual sale, something like that. I don't know. There's must be some workable language through there, I think.
Yeah, Mr. Chairman, I think the receipt is easy to deal with, just making sure it's explicitly, you know, excluded from the Public Records Act. Our financial statements and the other revenue streams are more difficult. You certainly wouldn't want a treasurer to not be aware that they only had a single sale, or that the amount on the financial statement would disclose, you know, by mathematically what the amount of the sale was, and unintentionally disclose it and then be subject to a misdemeanor. So that would be our concern.
Everybody following? Maybe you could help us with some language about the receipt to be, if that could be, Representative Sweeney.
Thank you, Mr. Chairman. So did you say Converse County?
Yes.
Yes.
Converse County is the center of tax thinking in Wyoming.
Absolutely. So as an example, I know that you've got a billionaire that has bought several ranches in Converse County, doing a great job agricultural wise, and on those properties. So I do worry about the agricultural loophole. Do you see a way that we could closer craft this for Jackson in particular, or Teton County, that as I think the chairman stated, trophy pieces, acreage that would better qualify things. Converse County, I don't consider a resort area, but Laramie Peak, I do. I mean, it's a beautiful view, but do you have any thoughts on that?
Treasurer Shell.
Chairman Cage, Representative Sweeney, I wish I did. Unfortunately, I don't have the expertise to answer that question in terms of agricultural classifications.
Thank you.
Fair enough. Anybody else for the treasurer? Anybody else online? Thank you, Treasurer Shell. If you can think of some language maybe about the receipt piece, that would at least be the low hanging fruit. And then maybe we could say as a backup, something about not disclosing any receipts in any period of time that would uniquely identify a taxpayer or something, or a particular sale or something. Okay. Anything else? Anybody else want to testify? You getting hungry? I hope you're getting hungry. Mr. Garrett, you getting hungry? Come on up.
I am indeed hungry, Mr. Chairman. Richard Garrett, American Heart Association. I am not going to comment on the specifics of this bill, but I will say as a matter of policy and principle, and echoing some of the remarks offered earlier, as many decisions as we can drive to the local level as possible is better public policy. There's no doubt. If we can avoid preemption, if we can assure local optionality, that's a good outcome for the American Heart Association on a variety of issues. And I'd be glad to explore those issues with you at some other time when lunch is not right in front of us.
Well played. Questions for Mr. Garrett?
If I may, Mr. Chairman,
Yes.
too, our beautiful state it's like a blanket or a quilt. Both will keep you warm, but the quilt is beautiful. And it's made with many hands and meticulously designed. And that's what our state is a quilt, a beautiful quilt. So I urge you to keep that in mind too, as you think about your vote.
Thank you very much.
Thank you.
Okay, anybody else? Anybody else online? Clear? Okay, you've heard everything. Committee discussion, and then I'm looking for a motion. Representative Yang.
Thank you, Mr. Chairman. I think many of you know that I am in favor of this, and I have quite a few amendments to try to make the bill better. I wanted to go over a couple of things. I think the basis of this is just a reminder of what kind of tax this is. This is a sales tax. The transfer tax covers, the gift portion, right? So a gift of land shouldn't be exempt from the same amount of tax that someone would sell at fair market value. So they're kind of lumped together. We call it a transfer tax, but it's a sales tax on what we've heard, $2.5 billion in transactions in my county alone, which has been going up year by year and has been kind of exponential during the pandemic, and has had some negative consequences for our community. And so we're trying to figure out, how do we mitigate some of those and handle it? Some of this money could be used for transportation, right? So it could make sure that we could hire bus drivers and pay them fairly, where they could justify accepting the offer to work on a bus, which right now is extremely difficult. Or it could be used with those public-private partnerships where the state participates in the free market, where they purchase land and then they use that land with a private-public partnership to initiate a housing project that furthers the community's goals. So the community's goals are trying to house workers in the community that they work in. So it could be used for both of those. I think the overall, again, it's just a reminder that this is a tool. I have some amendments on the flexibility of the $1 million, and I put that in an email to you guys and Mr. Anderson. But I think overall, I would urge that my community is getting in a crisis point, and without getting more tools in the toolbox, we really are going to be in trouble. And the idea from Mr. Riemann from his presentation at our last meeting was, which is why the direct distribution part is in this bill, I think also allows for a community like Jackson Hole to contribute more to the state. So we can't directly have a county optional tax go to the state, but we can do this offset of a direct distribution. And it still requires calculus from the county to help decide whether it does make sense for that county. And I really don't think it will make sense for a lot of counties, but I do think it would make sense for ours. And so I truly do hope that you'll move this forward. And I'll be happy to talk about any questions that you guys may have as well. Thank you, Mr. Chairman.
That sounded like a great speech for just before we vote, but we got some work to do. I'd like to get a motion on the bill. And we're standing between us and lunch. So can I take that as a motion?
Mr. Chairman, let's end that speech with a motion. I move the bill.
Okay.
Second.
We got a second by Sweeney. All right. Proposed amendments. Who wants to start with proposed amendments? Who's got one? Senator Schuler.
Thank you, Mr. Chairman. I would like to make a motion to amend on page 6, line 15, take out assessed value and put down actual or fair market value.
Would you accept as friendly fair market value as determined by the county assessor?
Yes. I forgot to add that. I really meant
Okay.
to. Sorry.
Is there a second to that? Got a second? I think it was the co-chairman. Discussion. All those in favor? Dr. Hallahan, your hands up. Did you want to address this? Or were you trying to get me my attention on something else?
Mr. Chairman.
Mr. Anderson.
Just wanted to note, I think we also need to make the same change on page 12, line 6.
Okay. Just go there real quick. We'll get the maker and the second to take a look at Page 12, line 6. There you go. Is that acceptable?
Yes.
Okay, looks like the maker and the second accept the change. Dr. Hallinan, you're awful scary. You're so close to the screen there, by God. We're looking like, anyway, okay. Any further discussion? All those in favor say aye.
Aye.
Actually, I'd rather you raise your hand because we got the screen situation. I can't tell. So I got 1, 2, 3, 4, 5, 6. Online, I got a 7. So 7 opposed to the motion. I got 1, 2, 3, 4. I got 4 opposed, 7 in favor. That carries. Any further amendments? Does anybody want to deal with the ag situation? Representative Yen, you go ahead.
Mr.
No-
Chairman, Mr.
Yep.
Chairman, I would just like to move the language that I emailed. So the language that I emailed would change the $1 million exemption language, which is on page, I don't have it on paper. It's on page 7, lines 6 and 7, which is the amount of every transaction. So the first $1 million that are transacted are exempt in the current language. I'd like to change that Romanet I to read for any amount of a sale up to the amount defined in the initial proposition, which may be up to $1.5 million. And so that puts a maximum amount on what a county can exempt and leaves that up to the county to put on their ballot the actual amount. And I would give LSO any leeway on adjusting conforming language to make sure that it works.
Let me just check before we seek the second. Josh, is this possible in concept or any other things? Okay, it's possible in concept. Looking for a second to the motion. Second by Sweeney. Discussion on the motion. Not seeing any discussion. Well, let's poll for the motion. All those in favor of the motion, raise your hand. I've got 1, 2, 3, 4, 5, 6. I got 7. Might be the same cast of characters. All those opposed, raise your hand. 1, 2, 3, 4 against. 7 to 4 again. So that is passed. I counted Representative Gray. I did. I counted Jennings, Baker, James, and Gray. I get 4. Okay. Any other motions? Does anybody want to deal with the ag exemption? I'm sure Mr. Moline would like to if he were here, but let's hear it.
Mr. Chairman, as described by the assessor, really for any transfer of agricultural land as classified by the assessor. This is a motion.
Okay. Got a motion, a second discussion.
Mr. Chairman.
Representative or Mr. Anderson, I'm going to get you a representative yet.
Sorry to interrupt, Mr. Chairman. I just wanted to note there is a definition of agricultural land. It's on page 2, lines 7 through 9, which just means it meets the requirements of the current ag land exemption. Based on a representative or
Pull that mic closer, Josh. I'm not sure.
Based on Assessor Huxtable's testimony, it might be important to clarify at what time that it would meet that
Right.
definition.
Okay, we got a motion and a deal, and we got some discussion from staff. I think my point is a piece of property may be classified for the receiving the tax exemption as agriculture. No question about it. They meet the $500 threshold. They put up some hay, whatever. That's easy. But the question is, when that same piece of property changes hands, the value of it changing hands may or may not have anything to do with the agricultural consideration. In fact, more likely in today's environment, if it's a nice place in a pretty spot, it's going to be multiple times that. So it's not, you're not buying it to put up the hay. You're buying it because it's a beautiful spot. It's where you want to live your life and raise your kids, and you're going to pay a premium. You still don't want to pay taxes on it, so you're going to run down to the courthouse and file for the exemption. But you're paying a lot of money for it. And I'm not sure why that should be exempted from this bill. But it's if you disagree, we'll just move on. Representative Ross.
Mr. Chairman, if I could, I think it's a tough one for me. I kind of agree with you in that is what is happening is these agricultural lands are being sold at really high prices, just not really for agriculture, but they are used in Teton County as a way to maintain open space. And it's quite valuable to the community, and I'm not sure how they would feel about that, but I just wanted to bring up that point. Thank you, Mr. Chairman.
So it doesn't take away the property tax classification. You'll always have that. And that'll keep your open space up. This is just for when it's sales. And if they break it up and sell it for 5 pieces, they're going to pay a lot more taxes, I assure you, than if it's one big place. So I'm not, if you have, say you have a square mile and you break it up into 40s, you're going to make more money with the subdivision and breaking it up into 40s than you'll ever make trying to sell the whole place. So why do we have to give away the store on the trophy sales? But this is just me. Okay, let's hear.
Well, Mr. Chairman, I totally agree with you. But how can we do that so that we're capturing that? There was reported yesterday, I read a report that there was a sale of a large ranch in Montana to a wealthy individual, and I'm sure he'll still run cows, but to pay $200 million. So I think we do need to capture that type of.
So there is a motion on the table, but if it's okay, we could have leeway. I think the way you capture that is to delete a little Romanet 12, line 18, page 9. It deletes it from being an ag criteria is deleted from being an exemption under the real estate transfer, but it still exists in the property tax statute, right? It would still exist. The assessor would still have the annual taxes based and give the ag exemption. Are people following me? I'm not trying to trick. However you think.
Mr. Chairman, I'll just withdraw.
Second agree. Okay, Representative Jennings.
Well, I'm not sure with withdrawn whether this is a.
Well, do you want to make another one?
Chairman.
Well, go ahead.
Well, the issue that I see with that is so the exemption is being used as agricultural land, and then we're going to tax the sale. And the next day, they're going to go back and apply for the exemption again. Seems like that's opening a legal problem there, that the property was agriculture when it sold, but then for whatever time it took to make the sale, we captured tax on that sale, but not changed the agricultural exemption. So it seems like the next day, it just looks like it might open a legal can of worms.
So there's 2 different taxes going on here. There's your basic property tax, which comes under the Constitution. Ag has to be valued on productivity basis. Constitution says that. We can't change that. If it sells for $1 bazillion above what the productive value is, that doesn't change the fact that they still get that constitutional level of ag-based taxes on their property tax. This is not a property tax. This is a sales tax, and it's a different animal. So that's why we can do it, I think, constitutionally. Josh, have I got that kind of right?
Mr. Chairman, yeah, I think that's the distinction here. I mean, I don't know that.
You're welcome to just say, how you're all stupid.
No, I don't know how the court would necessarily interpret that, but I think that would be the distinction I would see, is that there's a difference between a property tax and a sales tax, Mr. Chairman.
So would anybody like to make a motion to delete the language on line 18, page 9? And we can vote it up or down and move on. And if nobody makes a motion, we'll move on anyway. Got a motion by Sweeney. I've got a second by Yen. Can I interpret that as a second?
Mr. Chairman, I'll second it for discussion and I'd like to talk about it.
Discussion, Representative Yan, back to you.
Mr. Chairman, I'm actually, I think you're correct. For example, if someone sells their large ranch and it's been previously assessed as agricultural land, but the intent is for a developer to buy that land and then develop it into whatever, right? Any other property, that buyer has gotten a tax break by buying agricultural land instead of buying other private land. So I do think that removing the agricultural exemption is a good idea. I'm a little worried that we still kind of leave this weird limbo part for the transfer portion. So I kind of, it would be my thought to try to amend it if it got into committee to try to fix that rather than deal with the agricultural exemption halfway now. So, I will probably vote this down depending on how the committee feels. But I do think that it's something that we should work on in committee if it goes to the session.
Fair enough. Dr. Hallinan, your hand up.
Thank you, Mr. Chairman. I think this is a killer amendment for this bill. If it gets to the floor, all the ranchers in our legislature will look at this and see that their ranch land is worth more than the amount that they get, that the assessed value is. And I think they would vote against this bill and kill it. So I would be against this bill or against this amendment because I think it's a killer amendment for this bill. Thank you, Mr. Chairman.
Thank you, Dr. Hallinan. I'd suggest that ranchers already know that their property is worth a lot more than the ag production. And remember, if it's a transfer within a family, it's a gift within a family, or there might be some consideration within a family, but you're keeping the ranch in the family. It's covered by the gift part of this, which is the fair market value as determined by the assessor, which would be based upon production. So that there is a little bit of safety valve, but points well taken, Doctor. You always make good points. Anybody else? Shall we vote this one up or down? Ready? All those in favor of the motion, I think it was a Sweeney Yen, to delete line 18, page 9 from the bill, indicate by raising your hand. It's going really well so far, I think. Come on, Yen, where'd it go? I got 1, 2, 3, 4. I see myself on screen. Can I count me again? Yeah, and Yen, nobody else on screen. I got 4 opposed. 1, 2. Roscoe's jumping in the fray. 3, 4, 5, 6, 7. Fails. Back on the bill. Anything else? Anything else on the bill? Anything else we missed out there that somebody can think of? Josh? Okay, well, then we'll go to Representative Jay, but Josh first.
Mr. Chairman, Ms. Arnold or Ms.
Henson
at the department had noted questions with the
timing.
No, with the confidentiality of the statement that is
Right.
filed with this. I don't know if you wanted to look into that at all, Mr. Chairman.
And Treasurer Shell was kind
Treasurer.
of talking about that too. So does anybody want to venture into that realm? And the motion I think you'd probably look for if you wanted to keep it confidential is that the taxes collected on a single parcel are confidential, and that any tax report requested in any particular period that identified a particular taxpayer would also be confidential. I don't know if that's possible, but anyway, you think about that. Representative Gray, we'll go to you. You probably have something different. Your hand is up, Representative Gray.
Yeah, I just wanted to make sure that I wanted to say something before we had the vote. So that's why I had it up. Seemed like we were about to vote, and sometimes I just want to make sure I wanted to do some general comments. So
Okay.
when we get to the point, if you could give me an opportunity, I appreciate it. Thank you.
Is there any other motion, any other amendments? Dr. Hallinan.
Thank you, Mr. Chairman. I have an amendment that I submitted to Josh to draw up. And the amendment essentially does this. It gets rid of that part on page 15 or on page 17. No, page 15, where it says that 50% of the taxes that are distributed to the county would be removed by the payment of this 1% that we get on the property. I would just substitute that 10%. I would take that out, that line 13 through 23, and simply add in that we would have a 10% of the amount that's generated by this 1% would go to the general fund. I think that's a simpler way to look at it, and that's what I have in the amendment. So with that said, Mr. Chairman, I would move that amendment. Thank you.
All right, Doctor. You're catching us. Would somebody second the doctor's amendment? Looking for a second. Doc, I'm looking everywhere for a second. Hang on, it hasn't really been distributed yet, so we'll hang on for a second. Or a minute for a second. Everybody's got this in front of you? So basically, he's getting rid of the deduct from the direct distribution, and he's going to take his money off the top, and it'd be 10% of the total taxes collected. So Representative Yen, I'll throw it back to you just to make us think about it. We do not have a second on the motion. We're looking for it. Do you want to respond at all?
Sure, Mr. Chairman. So, I think that idea has been contemplated by myself and Representative Schwartz many times. And what we hear from LSO is that we cannot directly, as a county, give a county optional tax to the state because it becomes uneven distribution, uneven taxation. So a certain group would be taxed more than others and not receive the benefits. The benefit of this offset of a distribution is that the tax money still goes to the county. We just ask for less from the state. And so the net benefit is still the same. The state gains and Teton County gains as well, or whoever implements the optional tax still gains.
Thank you, Representative. We'll go to Mr. Anderson. Is that kind of something?
Mr. Chairman, I'd let Representative Hallinan know. I thought there may be some potential issues with this. I hadn't had a chance to look at some of those old memos we might have given on that type of issue. So I hadn't looked deeply into that, but I did let Representative Hallinan know that it may raise some questions.
So it's not definitive at this point in time, Representative Yen. So it's a good tactic. So the chairman is still looking for a second for the original motion, now that you've had a chance to learn a little bit about it. So, and it's the one in your hand, looking for a second. I don't have a second, Dr. Hallinan, but I suspect this won't go away. Thank you, sir.
Thank you.
Any possible motion with respect to the confidentiality of the receipt and that stuff that Ms. Henson had said? Do you have any more ideas how that could work, Ms. Henson, and maybe Treasurer Shell too? Come on up. I appreciate you thinking with us.
Mr. Chairman, Brenda Henson, Director of Revenue. The only thing I wanted to touch on is on that page 12. I agree with the proposed amendment where we're talking about the statement is not public record and the reference to the county treasurer. But I think it's confusing when we still have language in there that says it shall be held confidential by the county clerk, county assessor. It would make someone reading the statute believe that they have access to it in the first place, and they don't. So I would just encourage, however that amendment is worded, that we remove all of those other entities that will not have access to the document.
Okay. I don't know how to get out of this box, but Treasurer Shell, you want to come up? Maybe.
Thank you, Mr. Chairman. I would propose that the amendment would be on line 12 or on page 12, line 14. After statement, insert the language that says receipt and revenues if disclosure of the revenues would identify the amount of a single sale, and then change is to are.
Oh, that's so good. So the statement, receipt, and revenues, keep going then.
If disclosure of the revenues would identify the amount of a single sale are not a public record.
Can I get a motion? I got one by Roscoe. second by Baldwin. Discussion. Everybody okay online? Josh, did you get it?
Yeah,
Josh
Mr.
said,
Chairman, where are we? Can you give me the page number we're on?
not if you're driving.
I'm in the parking lot.
Okay, page 12, line 14, after the word statement, I'm going back to Treasurer Shell.
Insert receipt and revenues. If disclosure of the revenues would identify the amount of a single sale, and then change is to R.
Is to R, so that would be the new language. So all the confidentiality applies to the particular receipt of the money and any disclosure that might reveal a single taxpayer or a single transaction. Okay, everybody got it? You ready for it? Representative Sweeney.
Thank you, Mr. Chairman. In addition to that, as noted.
We'll get to the notary next.
And also county clerk, assessor.
I think if this motion is successful, the statement one is not, and the rest of that language, not a public record and shall be held confidential. I think it applies to all of them: county clerk, county assessor, county treasurer, county board of equalization, state board, and by the department. I think everybody's caught up in it.
Okay.
If it's a unique sale, that the reporting period or the receipt or what have you, taxpayer, I think this is going to be good. All right, so let's just vote on this one. All those in favor, raise your hand. I've got 3, I've got 5, 6. I've got everybody but Gray, I think. So all those opposed. Okay, Gray's opposed. Okay. Now, in this same, so that has passed, but in the same paragraph, Ms. Henson had mentioned that we require a notary and that we don't do that elsewhere. Does everybody see that? That's on lines. So if you get a sale, the grantor and the grantee shall sign before a notarial officer on a form prescribed by the department, a statement eliciting the information necessary. Anybody want to go down that road? Get rid of requiring the notary? Anybody? So a lot of people think that notaries guarantee the quality of the information, you guys. It's not it at all. All a notary is doing is saying that the people that signed it are the people that signed it. Do we really need to do that so that you have to go to the bank when you sell property? It doesn't say that they said the right amount. It might be $1, $12 million, or anything in between. It just says that the signatures on the two things are the people that signed the two things. So when you throw the notary requirement on everything, it doesn't make the information pure. Anyway, that's my thought. So I'd get rid of the notary if you wanted, but I'm not hearing a motion.
Mr. Chairman, I'll move.
Okay, got it by Yen, and Senator Schuler is going to back you up on that. Is that okay, Ms. Henson? Does that get at what you were thinking? And to accomplish that, would we just get rid of the whole sentence? How about the grantee and grantor shall sign a form prescribed by the department, and just delete the notarial officer. Got it, Josh? Okay, thank you for that motion, Representative Yen. Well thought out. Further discussion on the motion? All those in favor of the motion, raise your hand. Got 1, 2, 3. Jennings is up. 4, 5, 6, 7. I'll go 8. Opposed? Got 1, 2 opposed. That motion is carried. Anything else on the bill? Anything else? Anything else before lunch? Question. I heard a question. We ready for question? Let's call the roll on this bill.
Mr. Chairman, I wanted to talk on the bill.
Oh, absolutely. I'm sorry. Go ahead, Representative Gray.
And for the record, 2 amendments ago on that confidentiality question, I did vote aye on that.
Okay.
There was a little latency. I'm very opposed to this. I think that there's been a lot of studies about the damage that these real estate transfer taxes do, and it's tremendous. It and they've looked at this many times in economics, and Senator Case maybe could comment on this. There's a lot of studies on these transfer taxes, and they're very damaging. The problem in Teton County is not going to be addressed by $10 million more in funding, which is what this, if they did adopt the transfer tax, what this would mean. The only solution to the problem in Teton County to drive down the cost is to increase supply, and that's the bottom line, and that's the only way. And the risk of another county adopting this is just way too much. I mean, in any other county, and I don't like it in Teton County either, but the risk of another county adopting this would be very damaging to their economics. And the way it would be presented in the ballot question and in the campaign in this bill is that the buyer is paying for it. That's not reality. This is going to be folded into the closing costs, just like everything else is, or it's going to be folded into the price, lowering the asking price, but increasing the amount of costs involved in a transaction. So it's only going to increase costs. And so the idea that and also if they want to do this, Teton County, they can do this on their own with their current direct distribution, with all their current revenue sources. But why do they? It doesn't make sense to me. I mean, they certainly have the money, and I understand that this would raise $10 million under the current rates, because it would be 20 million and then $10 million they take off their direct distribution. But I don't understand. It's almost like that there's a certain section that they need to tie any expenditure to a tax in that sector. It's very odd to me, and it's something I've seen in the legislature that does not make any sense to me. They have all sorts of other revenues. If they want to do this, they have the local control to be able to disperse those to do this. And so I think that the damage that this could do to our economy, and there's a reason why the realtors are against this. And keep in mind that that's one of our booming industries right now. There's a reason they're against it, because they know that how chilling this is going to be in a key industry in our state. So it's just going to increase costs. It's really not going to fix the problem that they seek to address. And I think that if another county did address it, it would be very damaging to their economic growth, to economic development. And so I'm a no on this bill. Thank you.
Thank you very much, Representative. Anybody else? Ready for the vote? Let's call the roll.
Senator Baldwin.
Aye.
Senator James. Senator Pappas. Senator Schuler. Representative Baker. Representative Gray.
No.
Representative Hallinan.
Aye.
Representative Henderson.
He's excused.
Representative Jennings. Representative Roscoe.
Aye.
Representative Sweeney.
Aye.
Representative Yin.
Aye.
Co-Chairman Harshman.
Aye.
Chairman Case.
Aye.
That passes.
What was the vote?
We have 4, 5, 6, 7, 8 ayes, 1, 2, 3, 4 noes, and 2 excused.
Thank you very much. So that bill has passed. Must be like 10:40 in the morning right now, but actually we'll take lunch. It's can we get back here by 2 o'clock? Is that reasonable? So let's take lunch till 2, and we'll pick up industrial revenue bonds and just work through our schedule. Thank you, everybody, for good work.